little bit after 10 o'clock. Thank you for attending today's virtual hearing, which considers private water supplies. That's part of the conjoined inquiry for 3 wind farm applications at Craiginmoddie, Carrick and Knockcronal, although Carrick wind farm representatives won't be joining us today. For the benefit of those who have not been involved in the inquiry session so far, or those on the webcast, my name is Keith Bray, one of the reporters, one of the 3 reporters appointed by Scottish ministers to consider the 3 applications and report back to ministers with our recommendations. The 2 other reporters that you see online with us today is Mrs. Levin and Mr. Reid. I'll be chairing today, but we'll all ask questions as we move through. Given we've had a couple of technical issues, can I just check that everyone can hear and everyone's connected and is able to speak? I mean, you can just give me a wee thumbs up or a nod, or I haven't seen any shaking of heads or thumbs down, so that's good. I hope you've all received the agenda, which was issued a few days ago, and again it looks as if everyone seems to be saying they have it. As you'll be aware, this session is being broadcast live, as with other sessions, and we've said it before, but we'll say it again. In taking part in these sessions, you're consenting to being filmed, and for that film to be used and stored, the images and the sound recordings, and that information will be retained for webcasting and training purposes, and it will be kept as a historical record. So we just need to make you aware of those factors. Just so we can all get to know who's on the call, if I can ask everyone to introduce themselves, and we'll start with the applicants and then the council and then any third party. So if I could ask the Craiginmoddie applicant to introduce their team.
Yes, so good morning, David Hardy, partner at CMS, and I'm heading up the team for Craiginmoddie. And then we've got Mr. Sam Wainwright, who is a principal environment consultant with Natural Power, and you'll see him on the screen. Mr. Wainwright, do you just want to say hello?
Good morning, everyone.
Thank you very much. So Mr. Wainwright will be taking the lead on most of the responses, as you would expect. That is our team this morning.
Thank you for that. And for Knockcronal.
Thank you, sir. My name is Vincent Fraser, King's Counsel. I'm instructed by Vincent Masons, and my instructing solicitor, Mr. McGovern, is on the call also. And my witness, who I can see is on the call, sir, is Lucy Pott.
Hello, I'm Lucy from Fluid Environmental, and I'm representing Knockcronal Private Water Supply.
Thank you, Phil. And the council's team.
Good morning. My name is Douglas Armstrong. I'm King's Counsel at the Scottish Bar, and I'm instructed by South Ayrshire Council. The council have 3 other members of the team, Dr. Rachel Dewhurst, who's the Technical Director for Water Resources and Hydrogeology at Stantec UK, and she will be speaking to most of the issues. Constance Lovin, who's the Environmental Health Officer at South Ayrshire Council, and Nick Lopez, who's Chartered Town Planner, Principal Planner at Stantec, who will be dealing with planning policy issues.
Thank you for that. And in terms of individuals, I think we have a trainer on the call today. Good morning.
Good morning.
Are you hearing and seeing us well?
Yes, perfectly, thank you.
And Ms. Trainer is the president at Dobbington Farm, just for anyone who wasn't aware or on the webcast. Okay, I think that's everyone in the call. The purpose of the hearing is to examine matters raised in the submissions and hearing statements We'll not go over ground that appears to be agreed, or where we do not consider we need more information. The session will be structured, that I will lead, and it will be based on the agenda, although I have a couple of slight suggestions in terms of the running order, and I'll deal with that in a minute. There's no formal presentation of cases and no cross-examination. I'll try and lead the discussion by starting off with questions. After that, we may get all the parties to respond, and that might kick off a discussion, and it might generate other questions that the reporters may have. If you have any comments or questions as we go through the hearing, please make sure those matters come through me, so we can keep things on track and in line with the agenda. Please also be respectful and let other parties finish their point before you come in, and that's even if you really strongly disagree with what they're saying. Just let everyone finish their point. It's likely I'll just leave it up to the team leader, unless it's obvious, to determine who answers the question. So I might just be using the terms council, Craiginmoddie and Knockcronal when I'm asking questions. If you've been on Teams before, you'll know that you can use the raising the hands function, and that will give me an indication that you want to speak. Failing that, you can just stick your hand up, and if I haven't come to you, you can wave it around until I do. So just make sure that you get the opportunity to speak. Please remember and mute and unmute yourself as appropriate as we go through, and I will try and remember to do that myself. I haven't been successful in that so far, but today I'm hoping I might be. You may have to hand the documentation in terms of core documents. When we refer to those, it's useful if you give the core document reference number, and if possible, paragraph numbers and electronic page numbers, just so we can get there. Don't be too quick in giving the reference, just give the reference and allow parties to find the documents. So don't rattle off too many core document references together, because we might ask you to repeat it. We'll move on once we consider we have the answers that we need to fill in our reports, and don't feel obliged to say anything if you're only repeating what's already been said or included in material, because that's all evidence that we'll be taking into account. But all that you do tell us today in the hearing may be included in our reports, and as a consequence, the three reporters will be taking notes and may ask you to pause while we do that. We expect all the matters on the agenda to be dealt with today. There's no expectation we'll go further than today. We'll just have to see how we progress. We may be able to complete before 4 o'clock, but that's the kind of target time, and we'll just see how things progress. And we'll take breaks as appropriate in terms of lunch, unless anyone has got any specific requests around the time for lunch. It may be around 1 o'clock. If you have any specific requests, just let us know. We will be touching on matters concerning conditions, and I know that we have a specific hearing session on conditions, and we will discuss that when we come to the agenda point. And it may well be that some of the discussion is left until the conditions hearing, which is, I think, on the 20th of June. Just on behalf of the three reporters, can I thank the council, the applicants and Mr. Trainer for taking us on the accompanied site inspection on Monday, where we viewed the physical sort of geography of the area, and we were taken to the points that the council wished to go to, and that concerns the abstraction site for Dobbston Farm. So thank you for doing that. Some other matters. I think we've sorted out a core document perhaps gone missing, 1022 technical manual. So hopefully everyone has got CD 1022 or 010.022. I'll probably miss out the zeros when I'm going through my core document references. I had indicated that we may suggest that there's a slight change to the agenda. For item well, actually, I'll highlight a couple of things for Craiginmoddie first. Actually, in terms of item, just so you know what's ahead, for item 5A, I'll be asking the Craiginmoddie applicant essentially to respond to the points that the council has made in, I think, section 5 of the council's hearing statement. So that section 5A will essentially be the opportunity for the applicant to respond to section 5. And for item 5B, that's the elements A to M, I think, in terms of mitigation. So there'll be an opportunity for the applicant to respond and for us to discuss those elements. So that's just a little a heads up with regard to what's ahead on item 5. We would also consider, if you're agreeable, to taking item 6 and then the first part of item 7, which is planning condition for Glenalla, after item 3. The reason for that is in preparation for the meeting, we realise that may allow the Knockcronal questions, if you like, to be dealt with. Thereafter, it's up to whether Knockcronal wish to continue to participate in the meeting. But if we deal with items 2 and 3, item 6, and then the first part of item 7, that would be all the questions that we would have for Knockcronal. So I don't know if the Knockcronal applicant or others have got any thoughts on that. Mr. Fraser.
So if everybody else is happy with that, we'd be very pleased to do that if we could. And then with no disrespect to everybody, we would drop off the meeting when we finish with our issues. So we would be grateful if that could be done.
Does anyone have any objection to that? No, okay. Well, that's what we'll aim to do. We have had an email in from the council regarding conditions, and that came in yesterday, I think, and we can discuss that under item 7. Is everyone aware that needs to be aware of that email? It provided a short update with regard to discussions on the email and an extract of the table on conditions with the council's view and the applicant's view on certain conditions. Is everyone aware that email was sent, and are you all happy that we discuss it under item 7? Yep. I don't see any dissenting voices or hands, so that's good. Okay, a reminder, if there's anything noisy going to be around you, switch it off just now. If you have an emergency, of course, just please leave the meeting. Before we actually get onto the agenda, is there any procedural matters just now, or anything in response to what I've said so far before we go on to item 2? No, I think everyone's happy to get into the discussion. Okay. Item 2 then is legislative sort of policy guidance context. If you can have the council's hearing statement to hand, and that's 1035. I just thought it would be useful if we used that on a basis to just get some agreement or otherwise on the context. So if I can take you to section 3, and that's section 3.11 to 3.14. Council has summarised there some of the legislative context. Can I ask, with regard to these specific paragraphs, 3.11 to 3.14, that's on electronic page 7, if everyone's there. Are both applicants able to agree that that's accurate as far as they're concerned? We can perhaps turn to Craiginmoddie first.
Mr. Wainwright, as I say, is going to be the primary respondent.
Any particular issues there, Mr. Wainwright?
Thank you, Mr. Hardy. Thank you, Mr. Bray. I think the main points of contention would be related to the relevance of the private water supplies regulations and the water intended for human consumptions regulations. So both of these were referenced in the application documents, but to the best of my knowledge, neither the private water supply regulations or the water intended for human consumption regulations are development planning control tools. There's also reference drawn to the Drinking Water Directive. In their consultation response, Scottish Water, which is core document 001.119, they confirmed that the only drinking water protected area under Article 7 within the vicinity of the development was Pen Wapple Reservoir. The drinking water protected area was considered in the EIA and is in a different catchment to the development and is not at risk. Those are my main points.
Thank you for that. I would probably allow the council to respond to that just now before I come to Mr. Fraser.
I think on this one, just to start, it will be Ms. Lobbin going to speak to this point.
Okay. Good morning, Mr. Bray. In response to the only legislation, we are the regulators for private water supplies. The local authority are SEPA regulate the outside waters, the surface waters, the groundwaters. The legislation pertinent to private water supplies, I have a whole raft of legislation that we work to, and we're authorised officers under the legislation. Each part we have to be authorised and able to carry out enforcement should that come to. We're also authorised under the private water supply legislation, the Housing Act, and all of the other legislation pertinent to private water supplies, because we are the regulators, not SEPA. The catchment is now included in the 2017 regulations. It's updated, and under section 16, it makes it a criminal offence for anyone to knowingly contaminate or damage a private water supply catchment. The 2017 regulations, we have the 2006 regulations at present, but very soon it is envisaged that there will be no differentiation between 2006 and the 2017 regulations. All private water supplies will be captured under the same regulations. Sampled and an analysis of the water will be done in the same methods, in the same ways. There'll be no differentiation. And this is because it's been agreed at the working groups that have been taking place over the past year that the water at the end of the day is for human consumption and humans have to be protected. I note that Mr. Wainwright was saying about the only water supply protected area is Pen Wapple Reservoir. That's under the mains water and the drinking water quality regulator. Overseas is a regulator for both the private water supplies and the mains water. And the mains water powers are separate to the private water supply powers. The Drinking Water Quality Regulator has three main powers. They have the power to obtain information, the power to entry and inspection, and the power of enforcement. And this is in relation to private water supplies. And that power then comes down through the authorisation of the officers and the regulators, who are the local authorities. And in the case of South Ayrshire Council, it's environmental health. So we oversee the private water supply legislation. It's our duty to care for and protect, support, and assist people who are living on private water supplies, who own private water supplies, who want to install private water supplies. Many of the private water supplies will never be on mains water. They could never be because of the distance they are removed from the mains water areas. The legislation pertinent to private water supply, the Housing Act, we have to take that into account. The Housing Act is one of the critical factors when we do a risk assessment of a private water supply. Basically, if a property doesn't have a suitable potable water supply within the property, then the property is deemed below tolerable standard. That's the actual wording, and the homestead becomes uninhabitable and value is dropped, and potential resale or basically detached property could have a notice served for demolition, and a semi-detached property could have a notice served for closure. That's a potential. We hopefully wouldn't get to that. Change of land use is a critical factor as well. It's something it's not actually thought about. Private water supplies are looked upon as, well, we can safeguard them by a buffer zone, and I'll come to buffer zones in a second. But the change of land use now that we are seeing being impacted by cumulative effect, and cumulative effect, I am including all sorts of land use change here. Land use change has the potential to contaminate. It has the potential to destroy. It has the potential to stop a private water supply. If the private water supply owners and users are not near mains water, and an alternative can't be found, then that is an instant problem under the Housing Act. 2017 regulations also stipulate about monitoring and quality. It goes into quite a lot of detail in the Act of Parliament, to which the officers, like myself and others across Scotland, work to and try and get other outside agencies, services, and people like the applicant to adhere to and to consider from the beginning of any application for land use change, whatever that might be. The technical guidance document, a very large document. I brought the hard copy with me today, which we have in the office, and we often refer to this. The technical guidance, again, offers support from the...
Sorry, Ms. Logan, I've actually got a couple of questions on that. So I think because
separate matter.
Because there's been quite a lot there in your response, I think I'll go back to Mr. Wainwright. I think he was his point was with regard to the application of regulations within a development context. Mr. Wainwright, is there anything you would like to query or ask in response to what you've heard, Ms. Logan?
I think I've made my position quite clear. I appreciate all the additional context that Mr. Loban's provided there. I guess the main omission that I would suggest be included would be with regards to the SEPA land use planning guidance document, which
I've got some questions on in a minute, so I think
certainly
we'll in a second.
Okay.
Yeah.
So sorry to interrupt there, sir. The point I was getting to is that I don't. Whilst many of the legislation, many of these pieces of legislation that Ms. Loban's referenced that they've been acknowledged in the EIA or the private water supply risk assessment, not all, but most. Whilst they've been acknowledged, they do not reasonably relate to the assessment of private water supply receptors or groundwater abstractions. And that's my main position. Thank you.
Mr. Fraser, for Knockcronal, is there anything you or Ms. Parker feels they would like to add to that discussion?
Well, I have nothing to add. So I don't know whether Miss Parker has anything she wants to add, but I certainly don't have anything to say.
I'd just like to say that basically most of the legal documentation is used as guidance, and that can be applied so that a development should be considering those sensitive receptors that are private water supplies. And the legislation does indicate that a habitable property should have a right to a water supply. It's just how the application of the legal documentation, how that's applied. But I'm sure Sam will probably come on to that a bit more. But as far as for Knockcronal, we're happy with how we assessed it in relation to that legislation framework.
Okay. That initial discussion was just to really get the parties' responses to what the council set out in that first part of the hearing statement. And before we get to SEPA's guidance and the manual, which I think were mentioned, I was just wanting to make sure that or ask if all parties had anything in response to what had been said in the next section in terms of forestry, because there's reference to the context with regard to forestry and private water supplies, and that's in section 3.2.1 of the council's hearing statement. There's 3 paragraphs there. And perhaps following the same order, Mr. Wainwright, perhaps is there anything in those paragraphs that you've got a difficulty with, or would like to make any comments on?
Thank you, sir. The main points would be that effects from forestry, including those related to private water supplies, are collectively considered in the environmental impact assessment and in the private water supply risk assessment. Pre-construction forestry operations are included as part of the development and would be subject to environmental management controls, as well as environmental and private water supply related monitoring and contingency planning. Such controls provide a greater degree of regulation and safeguarding than would otherwise occur during routine forestry undertaken by forestry managers. So that's the main points that I wanted to say. Thank you.
And anything in response to that from the council?
Again, Ms. Logan will come back on the points of that.
Yeah, with regard to forestry, as I had pointed out, Mr. Bray, that I would include that as part of the cumulative effects, along with everything else that's taking place. I understand that forestry takes place, but we get plans normally before us and go out and site with people from forestry workings to look at the risk assessments of the properties, the private supplies from the catchment down before a plan is agreed. But that in conjunction with all of the other construction that's proposed, forestry has to be taken into account alongside all of the other construction and the land use change with regard to properties, property value, private water supply, and the potable water inside the property. It has a potential to damage or destroy private water supply, just the same as a digger has or a vehicle. And vehicles, heavy vehicles, it's the types of vehicles nowadays. Forestry has changed. The forestry that's getting felled now was planted decades ago. Types of vehicles, the weight, the size, the mechanism that's used. And quite often, it's not unusual for us to request round about a catchment area or an abstraction point or tanks or supply lines. It's not unusual for us to request that woodland or trees is removed by hand. And that's done in conjunction with SEPA. Although we don't work to the SEPA guide, we are not authorised under the SEPA legislation. I do work very closely hand in hand with officers from SEPA, and we go out on site and do the risk assessments with the applicants and the forestry for land management plans for all sorts of different things, like this application here.
And in terms of guidance, you referred to 1036 as the forestry guidance on protecting private water supplies.
Yes.
None of the parties are disagreeing that that's a piece of guidance that's relevant. Mr. Wainwright?
I wouldn't disagree that it's relevant. What I would highlight is that the recommended buffer distance in that document is 50 metres upslope or up gradient of the abstraction, so or water source. So in terms of Dobbingston, we've used the SEPA land use planning guidance document buffers, which I appreciate we're going to come on to in a minute, which are set at 250 metres for excavations greater than 1 metre deep. The nearest forestry felling within the vicinity of Dobbingston abstraction is 460 metres, and the turbine excavation is 660 metres. So we're clearly well outside of the required 50-metre buffer that's outlined in this document. So we've provided a greater level of safeguarding.
Thank you for that.
Thank you.
Perhaps if I come back to the council with regard to that guidance, that's a piece of guidance that you would work to with regard to forestry operations. And you heard there Mr. Wainwright pointing to a particular piece of guidance within it. Any matters that you would want to respond to there?
Just coming back on that, I think if Ms. Loban starts and then Sir Dewhurst has got a comment on that particular issue.
Okay, thank you. With regard to buffer zones, I have to point out on a regular basis, as I'm doing now, that buffer zones are simply guidance. They are not legislation. They're not acts of parliament, and buffer zones can be increased if necessary, but they can also be decreased if necessary. And I understand Mr. Wainwright saying that the guidance says 50 metres and working to SEPA's larger buffer zones. However, the catchment zone for Dobbingston private water supply is uphill. It's a steep gradient. It's a great distance from the actual abstraction point, as you pointed out with the meterage. And I believe you're taking the meter calculations from rough calculations we did on mapping for South Ayrshire Council to get the idea of the distances involved.
Let's leave our discussion for Dobbingston until we get to that point, if that's okay. I know Mr. Wainwright mentioned it there, but we might start to get into a discussion then that jumps ahead onto the agenda. It's really just to clarify what guidance and legislation what to do. But I think you've clarified that that's your view, that's the guidance, and you gave us your additional comments. Is there anything else you would like to add?
Yes, guidance was updated in 2018 due to local authority officers such as myself and in conjunction with other officers such as a colleague I work with through SEPA. When we observed the problems being encountered by private water supplies and forestry, planting, deforestation, felling, etc., etc. And that's why the guidance was brought in. But as I say, the legislation supersedes that. The 2017 regs take precedence in that. They protect the catchment. The European directive takes precedence in that. It protects the catchment for the waters.
Just before I take in Ms. Dewhurst, I will give Mr. Wainwright perhaps an opportunity just to reply to those last couple of remarks.
Thank you, sir. I don't think there's anything further that I'd like to add on that. I think I've made my my statement clear. Thank you.
Dewhurst.
I was just going to state that the important thing about the forestry guidance is that it brings into play the catchment, which is not actually considered greatly within the SEPA guidance at all. And actually it's the protection of the catchment that protects the source of water. And that's the critical aspect. That's all I wanted to say.
Is there a particular reference or paragraph within the guidance, or are you quite happy that I can find that easily?
You should be able to find that yourself.
Mr. Fraser, anything on what you've heard with regard to the context of forestry and private water supplies?
Well, I'll leave that, I think, to Ms. Parker again, if I may. So I have nothing to say on it. Thank you, sir.
Just generally, the forest and water guidance tends to be a little bit less conservative than what we do for wind farm sites. So that guidance has been considered in our assessments for Knockcronal, as well as the more conservative guidance that we're going to come on to. So the forest felling activities and forest felling activities has been considered for Knockcronal.
Thank you for that. That I think takes us on to the SEPA guidance, and so Wainwright has referred to, and it's been referred to in the submissions. I think that's CD 1014. So it might be useful that we have available, and the key matters that you referred to was those buffer areas, and you quoted, I think, the 250 and 100 meter buffers for different depths. Are all parties agreed that that's a key piece of technical guidance for assessing developments? I suppose that's the first question, and I think I would come to Mr. Wainwright first on that point. Is that the key piece of technical guidance that developers would look to?
Thank you, Mr. Bray. Yes, the SEPA Land Use Planning Guidance Note 31 forms the basis for considering risks to groundwater abstractions in relation to development planning. So we've referenced this guidance document in both the EIAR and in the private water supply risk assessment. The guidance identifies these two buffers to protect groundwater abstractions, which, as I've previously said, are set at 100 meters for excavations associated with a development that are less than 1 meter in depth, and 250 meters for excavations associated with development that are greater than 1 meter in depth. I would also add that these guidelines are referenced in the local development plan for South Ayrshire Council in their supplementary guidance to wind energy, which is core document 007.004, and if it would help, it's part H, electronic page 21.
And we may come on to discuss the relevance or currency of that document actually next week. But thank you for those. Is that the points that you were wanting to make?
Yes.
Okay. Maybe I could just ask you with regard to the matter of how does it deal with catchments? Does it provide any guidance for you as a developer in terms of assessing the impact on catchments, or does it primarily focus on the point of abstraction?
So it's specifically for groundwater abstractions, and there is an element of the document that requires detailed assessment when you're working within the buffer areas. So when you're working within the buffers, you would look to develop a conceptual site model, which would look at the various source pathway receptor relationships. That would include looking at the various ways that shallow groundwater that could be topographically constrained, that would be related to the wider catchment, could support or provide a source of water to the abstraction. As part of the assessment that we provided, we looked at both these groundwater buffers, and then we've also done a more detailed assessment that surpasses the requirements of this document, looking at the surface water catchment. Like I previously said, it's topographically constrained.
This guidance isn't relevant to supplies that have a surface water catchment. Is that what you were saying then?
So this guidance document does not relate to the protection of surface waters. It relates to the protection of groundwaters. It says that, sort of describes that in the opening paragraphs, that of its relevance to groundwater abstractions. It also relates to what are known as groundwater dependent terrestrial ecosystems. So it relates to both of those things, both of which are groundwater resources.
Thanks for that. I think maybe give the council the opportunity just to respond, I think, to Mr. Wainwright's submissions there with regard to the relevance of the guidance.
The Dewhurst will deal with that.
Thank you. Yeah, I agree that the SEPA guidance is useful in this matter, but it doesn't. But by implying that the catchment is topographically constrained, he's actually Mr. Wainwright is actually talking about a surface water drainage catchment and not a groundwater catchment, and by ignoring the relationship between catchment and water quality, he's not actually dealing with the issue of potable water supply. It's using an arbitrary buffer zone, which is merely guidance. There's quite a contrast in the guidance in the documents between what's provided in the private water supply technical guidance manual and SEPA's manual in terms of just looking at this whole catchment question and whether you should be concerned about activities within the catchment. It's useful guidance, but it's not necessarily the whole answer. And the way that it's been applied is mainly on a surface water application when it talks about groundwater, and that considering the groundwater has not been kept out.
We'll get into that because I think that those comments are directed probably towards the Seth Dobbington, but I'm trying to just stick to the kind of slightly broader questions about the application of guidance. Mr. Wainwright, I think you had your hand up though, so I will let you come in.
Yes, thank you, sir. It was just responding to some comments there, just to highlight. I appreciate that we will be discussing Dobbington in a little more detail later on, but it was just to highlight that the risk assessment that we've provided, which we'll also be speaking about a bit later on, did consider the various means and catchments and sources of water to the abstraction. So whilst Dr. Dewhurst is correct that the guidance is a good starting point and is a mandatory requirement for development planning, we have surpassed the requirements of it to provide a conservative assessment to improve residual risk minimization and confidence in the assessment. Thank you.
And I'm sure we'll have an in-depth or a more in-depth discussion on that as we move forward. But just staying on that SEPA guidance, does the applicant have any does Mr. Fraser have any comment to make for Knockcronal?
Again, I'm happy to hand that over to Ms. Parker, if I may. Thank you.
Thank you. The SEPA LUX 31 guidance is the accepted guidance that's used for assessing private water supplies that are on groundwater. supplying it specifically for groundwater. Most assessments would go a little bit beyond that and assess catchment basis as well, which was what Sam was referring to. But that will also take into consideration if it's a groundwater private water supply, the type of geology that's beneath the surface of the ground and how that acts in relation to the topography. Basically, it's a generally accepted guidance.
I think we can probably go on to the technical manual, but Mr. Trainer, I will be coming to you at the end of the item on policy and guidance to see if you have any particular points. But I thought I would just do that at the end of the point, so I'm not ignoring you on this item on the agenda. So let's go to the private water supply technical manual. I think that's the document that might have been in the core document list and then went missing, and it's reappeared for us. So that's good. I think it's section 4 that's highlighted as CD 1022. In the council's hearing statement, I think you reference or take us to paragraph 4733 of the technical manual. Is that the key part of the manual with regard to assessing the types of private water supplies we're dealing with today? I think that you stated that paragraph 5.1.20 of your hearing statement. That's of any use.
Yeah.
Where you cross-reference to the technical manual, and I just want to make sure that reference you've given us is the key matter to take into account, or and there are more elements of the technical manual that are of importance. So perhaps I can come to the council first on that.
In 5.1.21 in my document in the hearing statement, I quote a part of the private water supply manual that talks about the physical disturbance of groundwater flow and within the catchment. And actually, I've used it to illustrate the impact of change of land use as on the potential for contamination and risk of quality and quantity changes to a private water supply. I know that the applicant said that it wasn't necessarily relevant to undertake that assessment because it requires lots of other information regarding infrastructure and protection of water quality from the householder, but actually there is a section that relates solely to land use change and how soils might change under construction, and that's what I've illustrated in 5.1.22.
So since you have raised it, I think the applicant for Craiginmoddie was questioning the application of the technical manual and the guidance there. So perhaps I can come to Mr. Wainwright first. In response to the points that you've heard from Stuart, or in response to the statements made in the council's hearing.
Sure. So my position with regards to the use of the technical manual is set out in my hearing statement under paragraphs 5.1.1 and 5.1.2. So as Dr. Dewhurst has pointed out, the assessment framework, and as Ms. Loban also pointed out, it's established by the Drinking Water Quality Regulator and is typically used by local authorities in fulfilling their duties under these regulations, and to the best of my knowledge, is not used in conducting environmental impact assessments. The procedure is predominantly observation-based and considers factors which are not generally related to the risk assessment of water supply from from a development planning perspective. These are some of the items that Dr. Dewhurst raised just a moment ago. These include things like stock fencing and its general state of repair, that kind of thing. Its purpose is also not to consider future baseline scenarios, and is associated with determining compliance with the two regulations, the private water supply regulations and water intended for human consumption regulations. Nevertheless, elements of its framework were incorporated where possible. These were taken into the private water supply risk assessment. This includes a matrix-based approach, which is shown in the private water supply technical manual. And that's shown in the document. And we also considered the different sources of water which Dr. Dewhurst was referring to, and changes in land use, the various catchment areas, the different sources of water, such as water from minor structural features from within the bedrock, or water from the soil, or overland flow routes. So I'm content that the assessment we've provided is comprehensive and in accordance with industry best practice. Doesn't need to be following the guidance set out in the technical manual.
And again, I think we'll probably come on to that again. Perhaps I could ask Knockcronal and Parker whether you agreed with Mr. Wainwright with regard to the application of the technical manual and his observations on its use, and not being, I think his view was not primarily for the purpose of development appraisals in terms of an EIA appraisal. Can I have your thoughts on that?
So in my experience, that's just used as general guidance rather than constraining planning policy for developments.
Sorry, I didn't catch that first part. Guidance.
In our experience, it's used more as general guidance rather than sort of a legislative purpose for assessing private water supplies.
Your view is that it would be used in an assessment as reference guidance.
It can be used as reference guidance, but it wouldn't be the main guidance we'd go to. It's more sort of general best practice.
Is there anything else the council want to highlight to me in terms of the relevance of the technical manual? Fair from Mr. Wainwright and Ms. Parker has said. Any of the representatives of the council? Nothing to add?
No, I'll leave that. Thank you, sir. Oh, Connie, you'd like to say?
Yes, thank you, Mr. Murray. I agree. Yes, that's guidance. It's technical manual guidance, and I hear and understand what Mr. Wainwright's saying. However, it's set out through the DWQR, the Drinking Water Quality Regulator, for people to follow, and it's to give a good comprehensive idea of what should be getting looked at with regard to protection of private water supplies. It's specific to private water supplies. And it's a guidance manual that we ask forestry to look at. We ask anyone who's doing any land use change around private water supplies to consider. Thank you.
For that. Getting towards the end of the questions that we have on, if you like, the legislative and guidance context, before we get into the nuts and bolts of what we're here to discuss today. But Mr. Traynor, do you have any comment on what you've heard already with regard to the relevance of particular guidance, or are you happy to defer to the council on that matter? Although I'm not putting those words into your mouth, but any thoughts?
Well, I do have thoughts. As you well know, we are extremely concerned about our water supply. I can't comment on the legislation or all the documents that are being discussed, but if a water supply is described as being sensitive and there is no alternative in place, then any guidance should be used very stringently, and any buffer zones could be enlarged, protection of catchment, protection of abstraction points. Our supply is sensitive. It's been assessed to death by various companies, and any buffers like the ones that have been mentioned, the 250 and 100 metre for the different depths, those should be used, I don't know what the right word is, it's not conservatively, but they should be extended because we have no alternative supply and our supply is very sensitive. And that's all I can say about this particular point. Thank you.
Okay, thank you for that. Is there anything else any of the parties wish to say in terms of the kind of context before we go on to item 3? No, it doesn't look like it. So my colleagues, no questions from Mr. Reid or Mrs. Levin on any of the content. We'll probably discuss, I think the council have highlighted and others have highlighted the kind of local development plan context and reference local development plan matters. And we'll discuss the relevant policies in the policy hearing on the 20th. So I didn't have any particular questions on that matter. Just for completeness. In terms of item 3 then, that's with regard to Knockcronal, with a specific, although it says discussion, I only really have a question. For your information, we've actually visited the general area on an unaccompanied basis, so we are fairly familiar with the geography of the area and have viewed the catchment that's highlighted in the diagrams. But it's really a question with regard to the access route, because the potential concern relates to the choice of access. And we're going to discuss transportation matters tomorrow, but is there anything further with regard to access route choice that would influence whether or not the private water supply in Glenalla was going to be an issue to be covered by planning condition? Have you chosen the route, or is that something for discussion tomorrow, Mr. Fraser?
No, sir. The position is we're still seeking effectively consent that could allow us to use either of the routes. I think the decision, subject to getting that, the decision on which route we would take is something that we would be making a decision on later.
Okay. It's relevant to keep considering this matter then with regard to Glenalla. Is there any relationship with the potential for Glenalla to be uninhabited as a consequence of any agreement? I think that's in the public domain in terms of some of the submissions that have been made by Carrick. Does that have any bearing on your application and the need to agree a condition in relation to private water supply for Glenalla? Does that have any particular bearing?
We haven't sought to argue that. So, I mean, obviously you may form your own view on it, but we haven't sought to argue that. We're content to deal with the matter by way of conditions.
And more generally now, moving away from Glenalla, because I think we'll come on to the condition later to have a quick discussion on that. Question to the council now. There was a number of third-party concerns raised with regard to private water supplies for Knockcronal. The Knockcronal hearing statement has considered those and responded, in addition to the assessments that were made in the EIAR. Can I just ask the council, as if you like the regulating authority, that they're content with what they've seen in the Knockcronal hearing statement with regard to the range of properties that they have looked at, and it may well be that Mr. Globan answers that question, Mr. Armstrong.
We can confirm that we're content with that.
We don't have third parties here today who have made the submissions, but I think I was keen to just double check that you were happy from the local authority's point of view. I'm happy to go on to talk specific. Well, talk to item 7 and item 6 as they relate to Glenalla. Sorry, Knockcronal. And then that would potentially allow Knockcronal to consider whether they want to continue. So on item 6, it's a very straightforward question, but we do need to report back to the ministers on cumulative effects. I just want to be sure that none of the parties here are concerned about cumulative effects on private water supplies between the two, potentially 3, but the 2 wind farms here today. There's no crossover, there's no cumulative impact that we need to report or consider. Just want to make sure we haven't missed anything. We can come to the council first.
We can confirm that there isn't a cumulative issue in relation to the council position.
And for Knockcronal?
So we can confirm there's no cumulative impacts. The Glenalla private water supply is in a separate subcatchment from the other wind farm sites.
I think that was fairly clear, but there have been a number of third-party representations making comments. So I was just keen to make sure that there was no concern from the council from that perspective. Mr. Wainwright, nothing to add?
No, nothing to add.
If that's the case, we can go on to a quick discussion on Glenalla and planning conditions. That's item 7. That condition, from the point of view of Knockcronal, seems to be agreed. And it requires monitoring an emergency contingency plan. So just want to make sure that there's not been any changes to that. There is agreement. Mr. Fraser. For the Glenalla.
Sorry, sir. I was struggling with my button. That's my understanding of it, sir. It's agreed. Yes, thank you, sir.
The council's point of view.
Yes, that's our understanding.
That monitoring is okay there. Okay. That's actually all the questions that I think I'll be asking with regard to Knockcronal. Due to the fact that a number of submissions that have been made have been followed up by the third parties in terms of attending or participating, I'm quite happy that I've heard from the local authority with regard to the Knockcronal proposal. I just don't know if there's anything from Mrs. Leven or Mr. Breed for Knockcronal. Hearing or seeing any hands coming up there. So what I would say is that the production of a hearing statement has been useful. We will refer to those in our reports to Minister, and they provide a useful summary. So although we have not had extensive conversations and discussions and questions today, that statement has been useful with regard to summarising the matters and dealing with some of the representations. So it's an important part of the process as far as we are concerned. So it's really up to yourself, Mr. Fraser, whether you want to continue on and listen in. There's no problem with that, but you will be glad to know that there won't be any more questions.
Okay. I'm very grateful, sir, and we are all very happy without meaning any disrespect to the inquiry. You'll allow us all to read now.
All parties were happy with that, so we'll just we'll be moving on to item 4 in the agenda then. But before we do that, I think it would be useful to just have a short break. We've been going for an hour or so now. I think it's always useful to have a short break. Shall we say we'll come back at past? That might allow you to boil a kettle and have a cup of tea. So I think we'll come back at past. Okay, I think we're just about to start. I see the trainer returning to their seat. So unless anyone has knowledge that people are not around, I think we can start, and that's on item 4, the Craiginmoddie wind farm hearing statement. Questions that are not related to Dobbingston. Although I did want to start actually with just clarifying something that I think if we look at the hearing statement from the applicant, that's 1032, CD 1032, and paragraph 3.5.2 in summary. Just want to be clear and get council to clarify it in terms of the council's objection. I think the applicant sets out there the objection on the grounds of insufficient information and the consequences of risk adverse impacts on Dobbingston and Doherty Cottage. My understanding was it was Dobbingston that the objection related to. So I just want to make sure and ask the council to clarify if that 3.5.2 is accurate in terms of their objection. Mr. Armstrong.
So the position of the council is just in relation to Dobbingston farm.
Is that your understanding, Mr. Hardy or Mr. Wainwright?
Yes, I think that there were sections of the section 36 response from South Ayrshire Council which did reference Doherty, which is why it was included in that statement. I do appreciate that it wasn't named explicitly within the paragraph 9.9.25, which is a summary of the council's position, but it was included for completeness and to take a precautious approach, really. Thank you.
Which has been useful to make sure that you address everything. But in terms of the council's objection, Mr. Armstrong has provided me that clarity. So that's useful. I don't want to report the wrong thing to ministers. So if we can leave Dobbingston farm water supply to one side for 1 minute. It's a question for the council that, given that we have had a number of third-party concerns raised, as with Knockcronal earlier, it would be useful just to get your view on the summary that's been provided in the applicant's hearing statement with regard to other properties. Table 4.1 provides probably quite a useful a list with regard to the properties and the summary or conclusions really at the end. I just want to make sure that the council are content with what you see there, excluding Dobbingston.
So excluding Dobbingston, we're content with the other comments, which is we don't have any issue with the other
comments. That's useful to know from your regulatory role in respect of what the representations that have been made. So you're in agreement with the need for proposed mitigation and conditions with regard to some other properties. I think they include engineering works. So you're quite content with that. So that's fine. I would perhaps just want to ask a question with regard to Doherty Farm in terms of the conditions there, you're quite content with monitoring and an emergency plan, as is kind of to be agreed with that condition. So there's no problem with monitoring on that supply from the council's point of view, is there?
No, fine.
So coming on to the conditions, there is obviously an issue we have with the wording of the condition, and we have put forward specific other wording. That's perhaps for the conditions section.
Generally speaking, you're content with the approach in very general terms of carrying out monitoring. That condition, yeah.
Sorry, could you repeat the question?
In terms of conditions, in general terms, you're content that the condition supports monitoring, ongoing monitoring.
Yes.
We may return to that later when we talk about Dovingston. But if I can take the applicant to their hearing statement and it's just going to find it. I think it's with regard to where you reference the need to be careful around Dykes Farm, Fields and Kilbride Farm. The supply source will not be affected by the post-development, etc. Is that a matter that requires a condition? Trying to find
Sorry, sir, are you able to repeat that last bit?
I'm just trying
in regards to the references.
I'm just trying to find the reference actually, because it seems to have disappeared. I'm going to come back to that when I talk about conditions, because it was essentially whether there was a certain aspect of your assessment of properties which required to be covered by a condition that hadn't been proposed. But I'll come back to that when I talk about conditions. And by that time, I will have found the reference. Trainer, do you have any comments to make on other properties other than your own? You are part of this discussion, and you've heard the council's view on the applicant's assessment of other properties and that summary table 4.1, and the council are quite content with that and the conclusions which have led to some conditions. Any comments on that from you,
No.
Ms. Trainer?
No, I'm happy with that. Thank you.
Right. So I'll come back to that a matter that I couldn't find with regard to conditions. So it'll be on to item 5 now. Before we go into discussing the assessments and different views on that and the mitigation, Sir Armstrong clarified that the council objects on the basis of insufficient information that the supply won't be damaged or destroyed. We also make reference to the removal of turbines, 2 and 3, and I think in the hearing statement, I think there is a suggestion that turbine 1 is a concern and should be considered for removal. I just want to make sure I know your position on turbine removal. Is your position that there's insufficient information, therefore those 2 or 3 turbines should be deleted from the proposal? Or is your position there's insufficient information, therefore the application should be refused? Obviously, there are implications if ministers are looking to change a proposal, and we potentially discuss that under conditions. But I just want to be double sure about the council's position. Is it that there's insufficient information and therefore it should be refused, or there's insufficient information, therefore we recommend turbines 2, 3, possibly 1 are removed from the scheme in some way?
So I think this is probably best focused in the CD 1035, the council's hearing statement, and paragraph 7.1.3. No, 7.1.2 and 7.1.3. And the assessment and considerations that Dr. Dewhurst has carried out in relation to this, and the issue really is that turbines 1, 2, and 3, and the associated infrastructure that she's refers to should be excluded from the scheme because of the likely impact on the private water supply. Pass over to Dr. Dewhurst just to confirm that's her position from her assessment.
That is the position that I took, yes. Because of the potential derogation of the groundwater catchment by the construction of all elements and the development of the wind farm for those turbines.
So just to be clear then, the council's position is that turbines 1, 2, and 3 and associated infrastructure, which I don't think you've mentioned, but the sites were pointed out to us at the site visit, should be removed. I just wanted to double check that, because obviously there's a slight difference between that and the council's objection, original objection, which was that insufficient information, therefore it should be refused. Is there a slight change of position there, Mr. Armstrong, that there's insufficient information, therefore we would request Scottish ministers to remove those turbines and associated infrastructure?
Well, it's obviously based on all the information that's now been gathered since the objection was made, and on that information, the council's position is that they're recommending that turbines 1, 2, 3 and the associated infrastructure should be excluded from the scheme. We're not saying that if further research, further work came forward that that could show that there wouldn't be an impact. All the information that we have received to date and seen to date, and Dr. Dewhurst's analysis of that and the issues concerned, is that these turbines and the infrastructure should be excluded. And there is no indication on the evidence that we've had so far that the scheme could go ahead with these turbines in place, not water supply.
Would it be fair to say in 7.1.4 at the end, where you say the council will therefore consider that the application be refused, is it fair to say without the removal of those turbines and infrastructure, the council view is that that the application should be refused?
Well, I suppose the removal of these turbines and that infrastructure would change the scheme, and you'd have to be satisfied that you have an assessment of the scheme. You have sufficient information to consider that you have a proper assessment of a scheme minus turbines 1, 2, and 3, and the infrastructure that Dr. Dewhurst is referring to.
Thank you for that, Mr. Armstrong. You're leading us on to questions that I will ask about that under conditions, actually. So thank you for leading us there. But I think I would like to just turn to the applicant now with regard to just what you've heard from the council. I think that's clarified the position for me. I don't know if Mr. Hardy or Mr. Wainwright
might be for me to start. That's very helpful. There hasn't been a change, it seems to me. Insufficiency of information is a call for further information that's been provided. What the council is saying is that you know, it's not satisfied in relation to those turbines. Not saying no. Obviously, we disagree with that position, but it's not saying no in due course. And then the final point in relation to EIA, of course, you'd have to be satisfied that there was sufficient information for you to make a decision if that's the one that you come to. Again, we don't agree, but if you didn't, our view will be that you do have that. So I think helpful clarification from Mr. Armstrong. I don't think there's much more to say.
I just wanted to go through that before we started the main part of the discussion, I think, today. And it's really going to be a discussion on section 5 of the council's hearing statement. Sorry about that, Mr. Dewhurst, but I'm going to concentrate on that because it provides the detail, and there isn't any argument about the location of abstraction. I think that's quite clear from our site visit that you're all pointing in the right direction, or the same direction, I should say. And there seems to be general agreement that there's not a lot of groundwater level or surface water flow data in the immediate area. But there are matters that there are clear difference of views. And rather me taking you through each paragraph and asking for a response, I think I would really invite, if you like, the applicant to respond to matters raised in section 5 and go through them. There may be a number of points. I think there will be a number of points. So I might ask that we pause and have a bit of discussion about the points that I think it would probably yourself, Mr. Wainwright, that will be making them. So it's really to use that section 5 as the basis for our discussion. And I'm essentially inviting you to just make comment on those as we go through. And if you feel that at times it would be appropriate to pause and allow for a discussion, then I would invite you to do that as well.
Okay, thank you, sir. So I think it would probably be most appropriate to start with the first paragraph then, 5.1.1. So the opening sentence, I'm obviously not going to talk through every sentence, but just on the points that I've noted that I'd like to discuss. So there is a degree of uncertainty in all hydrogeological risk assessments due to the nature of the ground and the heterogeneity of its groundwater flow systems. Dr. Dewhurst has acknowledged that we've pointed this out in the EIAR, private water supply risk assessment, and I've mentioned in my hearing statement where there's uncertainty. She has said in the end of this paragraph that the application documents we've provided aren't in accordance with the precautionary principle, and it is lacking and is therefore not protective of the water supply as required by the legislation. I would disagree with that. The SEPA LUPS guidance, which, as we've discussed earlier, is the guidance for considering groundwater abstractions, requires detailed assessment where abstractions are within 250 metres or 100 metre, depending on the excavation depth of development infrastructure. However, Bobbingston abstraction is obviously far beyond those buffers. However, we have still provided a comprehensive and detailed assessment that is in accordance with industry guidance and best practice. They were validated by detailed site surveys. We considered all of the different water sources and considered those conservatively. An example of this would be where we have considered risks to structural features within the bedrock, which refers to faults, fractures, that kind of thing. And we considered that there is, although there are none mapped, there are no major structural features mapped. It's possible that minor features, sort of smaller fractures and faults and things that provide a supply of water to the abstraction may exist. To be protective of that supply, we considered those risks as being likely, so suggesting that they are likely to be present and part of the supply system. What we've suggested to accommodate for that is that there will be additional mitigation to safeguard against any disruption or contamination of that water source. I'm happy to pause there if council wanted to respond to any of those that I've just raised.
Council, I'm assuming it may be Ms. Dewhurst who responds.
Yeah, so what I would say is that while the additional information that was provided was very useful and made some steps towards addressing some of the uncertainty within the system, it's still not adequate to deal with all of those uncertainties. And actually, my main objection was around the way that you had portrayed the catchment for the water supply, in that you had identified a component of groundwater flow into the abstraction point from the sample that you took, which is fine, but you hadn't then extended your catchment to include groundwater recharge zones that have potential to be in that place. So areas where rainfall would occur. And I understand that there is uncertainty, but there is quite a lot of till cover on the slopes and peat, both of which would impact flow, would flow down to the bedrock. So you do need to incorporate some of the areas where there is no cover in order to accurately. It's not really accurate, it's geology, but in order to make sure that you are precautionary in your catchment area.
Thank you. So with regards to the determination of the catchments, so we acknowledged, like I said, that there was some uncertainty there, but one thing I'd point out is that the desktop assessment that formed part of the design of our conceptual understanding of the site, which is presented in the private water supply risk assessment, which is core document 1.095. There is, in that section, there is a statement on document page 8, which is referring to aquifer properties. Now, the information from that was derived from published information, as is referenced in the document, British Geological Survey information, baseline groundwater Scotland information. One of the statements in there is locally groundwater flow in the bedrock is likely to broadly reflect topography, although its fractured nature means that bedrock catchments may not necessarily coincide with surface water catchments. So we've accepted that, and I accept we haven't illustrated any groundwater catchments, but I think the key takeaway there is that the majority of the groundwater flow will be represented by the surface water catchments, and in that sense, these catchments make a good proxy for modelling groundwater. the uncertainty that's related to the movement of water in structural features, which may not coincide with these, is significant depending on the orientation of them, the density, the distribution, temperature, all of those things. There are no major structural features mapped, but we did look at the geology. I personally inspected geological exposures and looked at those, and that information's in the private water supply risk assessment. And we considered that there could be minor structural features, and those have been included, and those have been considered.
Is there anything that you would like to respond to that, Mr. before Mr. Wainwright moves on to perhaps other points he wants to raise?
What I will say is, I understand that he's gone out and mapped the surface water catchment and walked over that area, but that is based on the superficial deposits, and actually groundwater flow along structural features and fractures and faults can cross those subcatchments and mainly reflect the more gross drainage area. So by not including areas of bedrock that are up gradient of the private water supply abstraction point, you've actually not included areas that could be contributing water to that supply. And those areas may be significant, especially when you've got low rainfall and the peat's not saturated and there's not water running across the top of the till deposits in that area. And the fact that you further can suggest that the catchment is smaller in paragraph 4.2.113 in your hearing statement, because of the forest drainage, which is less than 1 metre deep, just shows that you're not really considering groundwater when you undertake your risk assessment, despite what you say in your paragraphs.
Playing a bit of tennis this afternoon, but I'm happy for that to continue. On that last point, perhaps Mr. Wainwright might wish to come back.
Certainly, sir. So water flow will follow, it will flow under gravity. So I think, Mr. Dewhurst, what you're referring to there is topographically constrained groundwater in the latter part of your kind of sentence there, when you're referring to the surface water catchment. So how we've considered this is in the private water supply risk assessment. It's stated in the risk assessment table that we've considered this. The weathered bedrock is may well contain water. It will be subject to the same controls, not exactly, but similar controls to surface water. So shallow groundwater will not flow uphill. It will not flow across catchments generally. It will flow down catchments, but not across catchments. So I think that's the main distinction I'd like to make on that point.
And just with regard to getting trainers' views, I was hoping to go through the council's hearing statement and then get the applicant's views, and then your views once you've heard those responses. But at any time, if you want to come in, Mr. Trainer, please just indicate, wave towards us. Is that okay? Okay, that seems fine. Mr. Wainwright, do you want to move on to any? I think that there will be a number of specific points you might want to make beyond that discussion.
I think a lot of my comments probably loosely relate to the determination of the two catchment, the two different types of water sources, and how we've considered them. This is clearly a difference of opinion with regards to these matters. What I would say is that the study that we've undertaken has been supported by exhaustive walkovers, and those are demonstrated in the private water supply risk assessment. We've far exceeded the typical standards of information that's provided at the environmental impact assessment stage, looking at the specific hydrochemistry of water at the abstraction, discussions with Ms. trainer about her abstractions during my site visit. Walkovers that have also focused on the soil. So we've looked at peak depths and its distribution across the site, and we've considered how that would influence the conceptual model. So how water might be moving through the system and arriving at the abstraction. And that's informed the risk assessment and also informed the need for mitigation, which we've presented along with the risk.
Dewhurst, I see you were tapping your pen there. It sounded as if you wanted to come in.
I was tapping my pen to just to keep me focused. Mr. Wainwright is correct in that the majority of our disagreement is about how the catchments have been defined. I have not queried his catchment walkover results with regard to surface water drainage towards the private water supply abstraction point, but I am querying his groundwater interpretation because I am more than aware that groundwater can flow down structural features that cross surface water catchments, which is what he's describing.
Okay. In relation to an assessment, would there have been any additional information that would have assisted? Because in some of the statements, I think it's quite clear that there is uncertainty. So I think my question to the council, having heard what Mr. Wainwright says, what additional information would have provided a bit more certainty in carrying out such an assessment? What additional information could have been provided?
I think I would have preferred to see more understanding of the hydrochemistry and the potential flow associated with this abstraction point, which I know is difficult because Ms. Trainer's concerned about people entering or being near her abstraction point due to previous issues. And I would also have anticipated that even if the risk assessment was then deemed to have a low risk, that there would be a demonstration of understanding of the impact of groundwater flow and potential recharge zones that might be influenced by a secondary flow system within the subsurface. And they weren't present in the documents that I reviewed.
Sorry, I didn't catch that.
I just said, Mr. Wainwright, I didn't say anything else. I just expected that you might want to come in to respond.
Don't have an awful lot more to add. I think I've really highlighted that we've gone above and beyond in terms of the information we provided, and then in an ideal world we would have been able to take more samples, and I don't think though more information would allow us to be any more conclusive in our risk assessment. I think that the uncertainty that we're talking about is a component of the water source that serves the abstraction. It's not its entirety. In my hearing statement, I quoted that other samples collected from other springs nearby did determine that the water emerging at sort of groundwater rises, springs and such were at best moderately dependent on groundwater. So it is a component of the system, not the system in its entirety. So I do not believe that, which is my opinion, that I do not believe the uncertainty that remains in this assessment is significant. And I'd also add that SEPA, as the regulator, are content that the information we've provided in terms of risk assessment on groundwater abstractions is sufficient to draw a conclusion on risk.
And the applicant doesn't wish then to draw anything to our attention further in section 5 of the council's critique, if you like, of the almost Wainwright's critique of the assessment. There's no specific points that you want to provide a response to.
I think there are specific points that relate to contamination and of the groundwater impacts and things like that, but ultimately these all relate to the risk assessment, which determines that a minor risk related to structural features may exist, but that is not significant in terms of the risk, and it is only a proportion of the flow of the abstraction, and that we have provided additional mitigation to safeguard any impacts on the system as far as possible. And that's in addition to standard good practice mitigation as well. Thank you.
Okay, thankfully the function on Teams tells me who put their hand up first. So, Ms. Traynor, you have a number 1 beside you. So, would you like to respond to matters that you've heard?
Well, obviously I'm concerned. Mr. Wainwright's describing his assessments, etc. But there is so much uncertainty here. The language that's used is, risks will be minimised. There's a possibility of this. There's a potential for that. There's no certainty here. In my view, nobody knows for sure where the water is coming from that is feeding into our abstraction. Everybody is surmising, but there's no certainty at all. There's a groundwater component, there's a surface water component. Mr. Wainwright saying that the groundwater component it's a contributory factor, it's a small component, and the drought conditions that exist in this area at present don't indicate that. When we were up at on site the other day, there's no surface water lying about anywhere where there usually is, yet our water supply is perfect and always has been. So to say that you consider the groundwater component as being a component and a small part of it, I don't think is correct. But I am not a hydrogeologist, as Dr. Dewhurst is. The uncertainty gives me great concern. The use of words like indicative, potential, for this and for that. Nobody knows for sure. And that's a concern.
You have your hand up.
I was going to make a similar point about the even a change in a minor component of a flow can make a water source unpotable. So not, it can change the quality and make it not suitable for consumption or for the treatment that is currently in place at the drinking point. So I don't think that it's fair to say that this minor component, if it becomes that the groundwater is a minor component, and if it becomes bad, it doesn't matter. It still matters.
In your view, Stuart, could there have been information, given all the uncertainty that we've discussed, been put to us, would it have actually been possible to provide additional information to try help clarify some of that uncertainty, or is your view that we're stuck with that uncertainty?
We're stuck with the uncertainty in the setting that we're in. It's not like, quite often I work in the southeast of England where there's plenty of site investigations happened and boreholes and all sorts of things. Groundwater and geology has inherent uncertainty in it, and it's about how you apply the precautions and sensible levels of risk to it, and that means assessing all components of the system, not just one.
Mr. Wainwright, do you want to respond to that? And I know that Ms. Traynor has got her hand up. I don't know if that's from earlier on, or you may want Mr. Wainwright first. Anything from Ms. Dewhurst you'd like to respond to?
Of course, and also responding to Ms. Traynor as well. So with regards to the commentary about the spring being running now, so I absolutely agree that the resilience of that spring at this time of year is likely to indicate that there is a groundwater component to that supply. However, at no stage have we said that there hasn't been. That the source of water will vary over the course of the year. At wetter times of the year, the spring will be far more dependent potentially on sort of local immediately upgrading inputs, which we've proven in the risk assessment are unlikely to be impacted. With regards to impacts on the bedrock and bedrock groundwater, for an impact to occur, there must be a pathway. So what we've looked at is a source pathway receptor approach. We've considered the hazards and how they could be transmitted via pathways to the receptor, which in this case is the water source for the abstraction. The site is covered in peat and it is covered in till, as Ms. Dewhurst has pointed out. So in terms of impacts on bedrock groundwater, there would need to be a pathway from the works through to the bedrock. Only, generally speaking, only excavations at turbines or on steeper slopes where you're cutting into soils and things like that, is there an opportunity for a pathway to arise. These areas are very limited to they are essentially limited to turbine foundations and things like that. So in terms of the immediate catchment up gradient of Dobbingstone, we've considered those. T2 obviously is on the edge of it, the indicative catchment, so it's potentially on the edge of this groundwater catchment, which is why we've identified that there is a likely pathway between them. We've considered that conservatively, and we've also included T2 and T3 in our additional mitigation area, so areas where we consider the risks to be a bit higher, and so additional mitigation and safeguards are needed to protect the private water supply.
Jenna.
I wanted to add, have I got my speaker thing on?
Yes, you do. We can hear you loud and clear.
I'm glad about that. Struggling with all these buttons. I wanted to add in regard to the groundwater and the surface water components. Because of the location of the abstraction point and the fact that the water flows down under gravity and it comes down into a steep valley, down to Dobbingstone Burn, it then crosses Dobbingstone Burn and it comes back up the hill onto what we call Dobbingstone Hill behind the house. So it's coming back uphill and then it's flowing back downhill to our tank, our storage tank. If there is a reduction in flow, that could stop that whole system working. There will not be enough flow to bring it down to Dobbingstone Burn and then push it back up to our tank. So the groundwater component, if you say that that's small, if that is affected, that has the potential to stop the supply completely, as has any impact on the surface water component of it. So if you affect any of those components that you have identified, and I'm not sure that they have been identified correctly or accurately or with any certainty, then it has the potential to cut off our supply completely. Mr. Wainwright just described pathways, identifying pathways. I would question whether it is possible at all to identify what fractures and fissures exist within the bedrock up above our abstraction point, which are feeding into our abstraction point. I don't think, and maybe I'm wrong, I don't think anybody can identify with any certainty what those are, where they are, or how they affect our supply. In addition to that, the recharge areas that are being talked about are giving me great concern. If I look at Dr. Dewhurst's report, and the recharge areas are identified on, I think, the maps at the back, Appendix E. The recharge area that's been identified for our supply is absolutely huge. And if you're talking about putting turbine bases and all the concrete and steel, plus all the other components, the geotextiles, everything else, you could be talking about 4,000 tonnes of concrete being put into our recharge zone, never mind anything that's going into the indicative catchment area. And 4,000 tonnes of concrete, 3,000 tonnes of steel. Now, even the sheer weight of that being put onto an area of ground where you don't know where the fractures and fissures are could have an impact on our supply. And as I say, I'm not a hydrogeologist, but I'm not stupid either. And it's our water supply and we're worried about.
Trina, you've taken us to Ms. Dewar's maps and plans. I mean, I don't know if Mr. Wainwright had any commentary on those as they've been illustrated to us, the way they've been presented. And you might want to respond to what Ms. Trainer has just said as well. Mr. Wainwright.
Thank you. So, Ms. Trainer, I'll respond to you first. So, in terms of determining fractures, you're quite correct. It is difficult, which is why we've assumed that there is a connection, and we have provided mitigation. We've considered the risk, assuming that they're there, and provided mitigation accordingly. In terms of the mitigation, we're going to come on to talk about that later on. We've suggested that pre-commencement of development, there'll be additional site investigation, and that will be to validate the findings of this risk assessment. So if at the minute we've assumed that there is a pathway and the risk has been mitigated accordingly. So if this assessment does not identify a pathway through intrusive investigation, then maybe that it provides comfort to stakeholders that residual risk minimization has been enhanced, that confidence in the assessment that's provided is improved. In terms of Ms. Dewhurst's models, I have reviewed those. I think there's clearly a difference of opinion there. So, as I've previously stated, the bedrock groundwater will loosely follow or be reflective of the surface water catchments, and that's presented in my risk assessment document, which I referenced earlier on. The catchments presented, I would suggest, probably haven't been validated by site surveys. One example of that would be Doherty Hill. I note that the suggestion is that there is water recharge from Doherty Hill to the system at what's described as outcrop. So that's where water is able to infiltrate directly through permeable soils to reach the bedrock. So as part of the environmental impact assessment, peat depth surveys were provided. Those surveys have demonstrated that there is peat on the top of Doherty Hill, which will limit infiltration in that area. If I do have a reference to that document, which might be useful for you to see. So it's contained in the peat slide risk assessment. It's electronic page 73, and it is core document 1.087. There is a single point on the top of Doherty Hill where peat was recorded as 0. All of the other points on top of Doherty Hill were recorded as 0.3 meters to 0.5 meters. So there is peat present, which is commonplace across the site. There is peat across the entire top of the site. Same as Craiginmoddie Hill as well.
That, Mr. Dewhurst, I think I'll come to Mr. Trainer first again, because you have a 1 beside your van, but I think Mr. Dewhurst also wants to respond. Mr. Trainer.
think Dr. Dewhurst will probably give a better response than me, but I want to express my concerns anyway. Mr. Wainwright's talking about, identifying where the things are, but it doesn't know for sure. There is no certainty at all. I've mentioned the amounts of concrete, the amounts of steel. Within the past 3 years, our road has been upgraded to make it into a forestry road from an farm access track. Now, I watched and was involved in all of that, and I was very aware of the amount of stone and the weight of the stone that was brought up in order to improve that road. Now, that's only to make it suitable for forestry. So it's not a huge improvement. And I'm looking at, in addition to all the concrete, the steel, etc., for all the bases, which could have a possible impact, the forestry road that exists at present is going to be upgraded, and it will be upgraded significantly. And all of the stone and all of the other components, steel, concrete, everything will travel across our catchment. And I've seen firsthand the damage that gets done by heavy vehicles on roads. Now, if you don't know where the fractures and fissures are, which you don't, and you accept you don't know for sure, how can you possibly say that you can put effective mitigation in place when you don't know what the mitigation is actually for? That is a question that I have.
I think that's a question that's been put, and I'm certainly unable to answer that. So I think I will turn to you, Mr. Wainwright, for your response.
So there's two types of mitigation, Mr. Trainer. We've got good practice mitigation, which is, it's not site specific. It will aim to maintain flow pathways. It's using things like cross drainage, there's pollution prevention, all those elements. And what they're aiming to do is reduce any distributed or distributable impacts that could be associated with the development on the water environment. What we've also provided is additional mitigation, and that relates to the specific uncertainty that you've talked about, and also it highlights the importance that the private water supply receptor is being considered. So what we've suggested, and I said earlier, we're going to move on to mitigation later, but we're trying to minimise the number of hazards that are being introduced into the immediate vicinity of the abstraction. So that includes things like avoiding the storage of fuels, oils, and chemicals, coming up with site-specific drainage and dewatering plans to try and minimise any changes to the local surface regime, hydrological or hydrogeological regime where possible. So that's the purpose of those mitigation. They're designed for that area and they accommodate that uncertainty.
Dewhurst, you've been patiently waiting. I'd like to bring you in just now.
I was just going to respond to the comment about peat being on top of Doherty Hill. As Mr. Wainwright is well aware, bedrock outcrop is based on the absence of till, not on the absence of peat. And peat, while it does prevent recharge to a certain extent, also acts as a water store, and water is emitted at the bottom. And it's not particularly thick anyway. So I just like to come back against that. Sorry.
And it doesn't look as if we're not disputing that. Mrs. Leven, I think, is coming in with a question.
Hi there, thank you. I was just following up on the point that Ms. Trainer made there about the upgrading of the road for the construction. And you talked about the road, those works potentially crossing the catchment for Dovingston. I wondered if the applicant could just clarify that in terms of, because I understood the construction access was coming from the U25, and so would those works cross the catchment in any way?
There is an access track that is existing and that will be upgraded. We looked at that access track on the site visit. To the best of my knowledge, there isn't likely to be any significant earthworks, although admittedly there will be some. In terms of traffic along that route, I'm afraid that's not something I know at this time, but I can try and come back to you on that before the end of the meeting.
That's okay. So Ms. Traynor, you were talking about, were you referring to the upgrading of the access within the site rather than the road up from Daly? Is that correct?
Yes, I was referring to the existing forestry road, which runs through our indicative catchment, and there's that funny word again, indicative, not definitive. All of that road will be upgraded. Now, I have watched personally the upgrading of the roads for Hagyard Hill. And if you look at the roads that are running through Hagyard Hill Wind Farm, there's a significant difference between them and what's qualified as a forestry track. And as far as I'm aware, all of the traffic will come from the access point from the U25 and will pass across our indicative catchment area directly above our abstraction point. Thousands and thousands of tons of heavy goods vehicles, all the concrete for all the bases. And their local experience as well, and I'm sorry if I'm digressing slightly, Kirkhill Wind Farm, just the other side of Daly, has just been, it's under construction at the moment, and the road there has been closed. And it was only supposed to be closed for 1-2 days at a time to allow bits of construction, repairs, etc. The road has been completely destroyed. It has collapsed completely. Due to the weight of the vehicles that have been using it to bring in these vast amounts of concrete for concrete bases, 700 odd tons per base, 500 tons of steel per base. That's all going to be transported across our indicative catchment area. And I fail to understand how anybody can say that that will not have a significant impact on our supply. Has that clarified that for you, Ms. Levy?
It has, thank you. Thanks, Mr. Bray, for letting me come in on that. Thank you.
Sorry if I'm repeating.
And just before I bring in Mr. Armstrong, who's waiting patiently, what we're talking about, I think, is the access track between 2 and 3 primarily, or are you concerned about the track beyond that in the kind of potential recharge zone that Ms. Dewhurst talks about, or are your concerns largely with the access track between 2 and 3? Because they go across the kind of indicative catchment. Perhaps, I don't know if Ms. Dewhurst wants to respond to that.
We're talking about the access track that is within the indicative catchment, so that I've shown on my Appendix E figures. So it's not only, sorry, it goes dark in here if you don't move. It's not only the short distance between 2 and 3. There's a bit more that goes up to turbine 4 falls within that.
And also between 8 and 9.
Yeah, yeah. There's a few other bits of track.
In terms of risk and uncertainty, is the piece of track between 2 and 3 of more concern?
That is of more concern because I understand that all of the traffic is going to be directed past 2 and 3 and then round in the loop. So that's the part of the track that has the heaviest usage according to the current planning.
I might come back to that in terms of mitigation, but Mr. Armstrong, you've been extremely patient.
Well, not at all. It was actually just to come back on 2 points, and Dr. Dewhurst has come back on that point. That I was going to suggest that Appendix E of the hearing statement helpfully sets out the access points and the issue. And it was just on one other minor point in relation to Mr. Wainwright, just to come back on where he did say a SEPA as regulator, they are, as has already been pointed out, not the regulator here, it is the council. I think of that there. Ms. Lober wants to come back on one point.
Ms. Loban, and then,
Thank you.
and then we'll
yes.
allow Ms. Trainer to come back in after that.
Okay, do I go just now, Mr. Bray?
Yes.
Yeah. Okay. To pick up on a couple of points there, you were talking about the directional flow. That was one of the things that I had looked at on the application, directional flow. And we're talking about mitigation here. And answer to Mrs. Levin, if the directional flow was reversed and turbine 2 and turbine 3 weren't present, if the directional flow was reversed, that would mean the traffic would not go across the indicative catchment. That's one point. The amount of traffic for the duration of the construction, but it's also not just the duration of the construction we're talking about for wind farms. We're also talking maintenance and then into the future decommissioning. So there's a lot of traffic and a lot of weight and associated things to do with vehicles such as oils and antifreeze, etc. Pollution is not just ground-borne, pollution is airborne, as well, as we saw when we were out in site visit. There's a lot of dust thrown up from the tracks. They're called tracks, they're actually roads within the forestry. And that dust can contain a lot of different pollutants. We in environmental health monitor air quality as part of our remit, and in towns, etc., and cities. And quite often we get pollution hotspots, and the pollution's not present in that actual area, but carries for miles in the air. So that brings me over to the point where a lot of potential impacts are not in the immediate locality of private water supply abstraction points and the catchments. They can be a huge distance away. They can be a huge distance away from the houses. The properties are taking the private water supply, and they can be a distance away from the catchments as well. So we have to keep this in mind, because at the end of the day, private water supply is exactly that. It's a water supply for human consumption. Now, it goes down to a private residential dwelling at the present, but those people that live in that house have people coming to stay. They have relatives coming from across the world. They have people coming to stay as friends, and other people are drinking that water. In the future, that could be a business. That property could be a business. It was potentially looked at as a business in the beginning by Ms. Trainer and decided not to go ahead. So we have to really look at the private water supply safeguarding here. It's critical. It's not something that we could maybe strengthen mitigation for. It's critical. It's human consumption at the end of the day. The bore wells round about are drying up. I'm monitoring the drought situation for South Ayrshire Council, as other officers in other council areas are doing. We're reporting back to SEPA, we're reporting back to Scottish regulator, who's a drinking water quality regulator, Rosemary Greenhill. Drought.
We've lost you.
All right.
Just because you, there's a bit of interference.
Okay.
So perhaps
Where did you lose
50 seconds or so.
Okay. What could
about
drought? The distance is critical, and the conditions and the indicative catchment, that's what it was on. So pollution doesn't just, it's not necessarily contained within the area. Pollution can carry from a distance, and it can carry in the air, and it can carry in dirt, and it can be brought in from other areas. So if you have forestry roads, for example, which are upgraded and filled with dust and dirt, then that can carry pollutants over. Drought is another factor as well. We talk about drainage and waterways, etc. If you're not actually looking at the private water supply per se, but you're looking at drainage to protect the bases of the turbines, etc., and people are thinking protect the bases or protect the roads, and the drainage has to make sure that the road doesn't collapse with a large vehicle so it doesn't cause a problem with oil, etc., spilling out. That drainage itself can then divert water away. And as I was saying, there is drought conditions now. We're in another year of drought. We're into the 6th year, continuous year of drought conditions. We don't always have hot drought here in South Ayrshire. We do have cold drought. The drought actually has started again this year in November, the previous year. I went back into work after the site visit on Monday, went back into work on Tuesday, and the numbers of properties is escalating that are now without water. The supplies have no water in them. We saw the ground conditions when we were out there on Monday. It's tinder dry. It's not just dry, it's absolutely tinder dry, which indicates to me the surface waters are gone. We really have to consider this private water supply is running. Not only is it running, the quantity is good, the quality is good, and it's a huge distance from the house. The reason I am led to believe that it's the distance from the house is because that is where the previous people decades ago found the water, the natural spring water to tap into. Now, I'm not saying it's not supplemented with surface waters. It is. I'm not saying it's not supplemented with intermediate waters. It is, probably. But that water is still running. The quantity is good, the quality is good, and the properties round about are dry. So that has to be taken into consideration. Back to SEPA as the regulator. Yes, you're quite correct, Mr. Wainwright. SEPA is regulator for waters. However, the drinking water quality regulator and local authorities are the regulators for private water supplies. There's a memorandum of understanding, and the memorandum of understanding sets out the framework for cooperation. It's not legally binding, but it sets out the framework for cooperation. And we have the EPA, which is responsible for UK drinking waters, and the Environment Protection Agency 2018. We have SEPA and Scottish Water, who look at the water safety plans and drinking water protected areas that Mr. Wainwright was so correctly talking about when he was talking about Penwhapple Reservoir. That's 2014. I might also add that Penwhapple Reservoir itself is a great distance away from Daly. Sorry, not Daly, a great distance away from Dobingston, and there is no mains water. There is mains water down to Pinmore, but there's no mains water available for miles around Dobingston. And if there were going to be any attachments to mains water, it would have to cross other private land other than the Miss Trainer's land. So the drinking water quality regulator, as I said, and the local authority, we do the regulatory enforcement powers for private water supplies. Part of that is protecting the private water supply owners as well as the private water supplies themselves, and supporting them to look after the supplies correctly. And in our opinion, if there's a risk that cannot be identified, cannot be positively identified, then that risk should be mitigated out completely, and that turbine 2, turbine 3 should be removed, along with the road and the traffic flow direction. That's what I've got to say. Thank you.
Before I bring Ms. Trainer in, I just want to be clear, and my colleagues are clear on the maps that are in section E, appendix E, Mr. Wainwright's hearing statement, when we're talking about indicative catchments and such like. We have an SW catchment, which is a kind of light blue colour.
That's the surface water catchment defined by Mr. Wainwright previously.
And then we've got the groundwater GW catchment supplying abstraction, and that's red, and there's a tiny little bit of red.
Red hash is kind of the area that you should be interested in. Red dot is reflective of the volume. So
it's the solid red, which
the solid red
is GW catchment supplying
yeah, that's an estimate. Yeah, that's the estimate based on the volume supplied currently.
Okay. And then the you mentioned the kind of red hatch, which is termed the abstraction buffer.
Yeah, so that's a buffer of 250 meters around that red dot.
Around that red dot. Now, does Mr. Wainwright, do you have any anything to contribute with regard to just clarifying what's on those plans?
So my understanding of these plans are only drawn from Ms. Dewhurst's statement. In terms of the indicative catchment area, which is indicated on that followed a standard approach to identifying watersheds based on a digital terrain model. So they use a 50 meter using the 50 meter DTMs, and for reasons I've previously stated, the indicative catchment area is conservative. The actual surface water catchment for the abstraction is likely to be smaller than this. In terms of the potential recharge zone, my understanding is that this relates to where water within the shallow groundwater could recharge to the abstraction. And I'm not seeing a head shake from Ms. Dewhurst, so I'm assuming that interpretation is correct. What I would add is that from what we saw on our site visit on Monday, the abstraction itself is not situated within the unnamed, it's situated adjacent to it in a kloof. It's on the far side of that kloof from where this additional area around T3 that Ms. Dewhurst has indicated. My opinion is that any shallow groundwater or overland flow would be constrained by the topography and would broadly follow the catchment. So to say, I do not think that water from the far side of the catchment that is topographically constrained would flow downhill and then up to the abstraction. The watercourse, they usually provide a reasonable proxy for catchment boundaries. So water will flow to the watercourse in a shallow groundwater setting, but not across or up.
And Mr. Wainwright, do you have any issue with how the surface water catchment has been drawn there?
Just to confirm, the surface water catchment, I think, is my yes. So no concerns with that.
I just wanted to clarify because it looks very similar to your own.
Yeah, pretty sure that's probably the shapefile I provided to Miss Logan.
I did take the shapefile you provided. Yes. Yeah. What I would say is that the surface water topography, the surface topography in that catchment has been very much distorted by activities and time, and therefore you can't actually definitively say that groundwater can't go from the top of Torty Hill to the abstraction point.
I don't think I was referring to Dotty Hill in that statement.
Sorry, from the turbine 3 area.
Turbine 3, okay, yeah. Sorry, just wanted to check there.
That's okay.
Strainer, you've been very patient with me. You've had your hand up. I'll let you come in now.
I'm struggling to keep up and keep my notes and keep in my head what I'm trying to reply to. Firstly, people are mentioning SEPA a lot. Now, when the Hadgert Hill extension was first proposed, the first people I contacted about our private water supply was SEPA. And I was told, private water supplies, that has nothing to do with us. And I know that this may have changed because I have had contact with SEPA recently, but there's a question mark there. As I said when you were all out on site, as far as I'm concerned, any works, any of this massive construction stuff that takes place on this side of the watershed, in other words, the ridge above our private water supply abstraction point, has the potential to impact. And not one of you can confirm or assure me that that is not the case, because there are too many uncertainties. In terms of the indicative catchments that we're all talking about, I can't remember how many assessments have been completed for our water supply. And all these maps have been produced by various companies, all showing what they call an indicative catchment, all of which are different. Every one of them. So that, again, massive uncertainty. And Connie mentioned airborne pollution. Now, this goes back to what I'm saying about this side of the ridge line, where the water, any rain that falls, has the potential to feed into our water supply, whether it's coming from over the surface, through peat, or through the groundwater. I have seen personally the amount of oil that is dispersed by turbines. Haggard Hill, again, and I have photographs of all of this, has turbines where there have been massive leaks. And yes, they put mitigation in place. They put bunds round the bottom of it. That doesn't stop the oil being on the blades and being scattered for hundreds of yards. Very fine droplets of oil. So if there are turbines placed this side of the ridgeline, above our abstraction point, even if they are a significant distance away, all of that pollution, potential pollution that comes from the turbines themselves, which I know people will say, oh, there's no pollution, we deal with it. There is, I've seen it. All of that has the potential to then go into the groundwater and feed into the surface water component and the groundwater component of our supply. So that's something that nobody has mentioned apart from Connie about the potential for airborne and other pollutants like the dust from the roads. I know the state that my car's in by driving on the road when it's dry. It's covered, it's got a quarter of an inch thick, very fine silt, which comes from the road. When the forestry road was built, when our access track here to Dobbingstone was upgraded to a forestry track, which I've mentioned before, all of that dust ended up going into Knockcronal burn, which runs past our house. And the amount of pollution that went into that was colossal. Now, there is potential for that to happen up above our abstraction point. And again, I have photographs showing the level, and that level of pollution that came from just upgrading a tiny wee road and not upgrading it to the same specifications as the road up at Turbine 2 and Turbine 3 will be upgraded. The pollution was evident in the Knockcronal burn. It was evident where we have the bird feeders, which you all saw. The water was grey. It was also visible down in Daly, at the bridge down in Daly. So even though you've got Dobbingstone burn and a Knockcronal burn feeding down to the river going into Daly, the pollution was evident down there as well. That's a concern for us as well. Thank you.
Thank you, Mr. Chair. Mr. Wainwright, maybe one more response, and we'll think about breaking for lunch before we discuss mitigation afterwards. Mr. Wainwright.
Okay. Thank you, sir, and thank you, Ms. Trainer, for your comments there. So I really wanted to kind of summarize here. So we've undertaken a comprehensive assessment of the risk. We've looked at all the different hazards and we've considered those in terms of the different water sources. What we've done surpasses the requirements of the SEPA land use planning guidance document, which is the standard for assessing risk to groundwater abstractions. We've accommodated for any uncertainty through additional mitigation in terms of pollution risks that Mr. Trainer's talking about there. Throughout the duration of construction, there's obviously an construction and environmental management plan that will include mitigation that will safeguard private water supplies. That will include things like dust suppression on tracks during dry weather, for instance. These pollution prevention plans will be prepared and they'll be consulted with South Ayrshire Council as well as SEPA to check that they're appropriate and fit for purpose. And it may well be that there'll be operational environmental management plans too that would control pollution during the operational phase as well. So yes, those are the main points that I just wanted to add in there. Thank you.
And that your last comments really take us on to mitigation and to talk about mitigation. Ms. Trainer, would you be happy? I know you have your hand up. Would you be happy that we broke for lunch to just now, because we are going to come back to talk about mitigation and go through essentially again Ms. Dewhurst's hearing statement. I think it's starting with point A, and we'll probably go through to M and discuss those. So are all parties content that we break for lunch and then come back to talk about mitigation? I would probably say an hour, so we come back at 10 to 2. Does that sound reasonable for everyone?
Yes. Yes, thank you.
That's great then. So we'll see you at 10 to 2, 1:50.
Thank you.
Thank you.
Okay, I think that is 10-2. I just double check that everyone can hear me. Yep, thumbs up would be fine. That's good. I think we're at item 5B.
Mr. Wainwright.
Mr. Wainwright's there. Thank
Hello.
you, Mrs. Clearan. I should have asked, does everyone think everyone's here? Okay. Mitigation proposed. And you'll need I think if we look at the council's hearing statement, and that's 1035, CD 1035, and there's a specific section. A number of points made on mitigation proposals, and there is also 3 points that the hearing statement highlights have not considered. So if you're all content, I'll just do them in the order that they appear, unless you think there's any alternative logic. And as before, I think I would come to you, Mr. Wainwright or Mr. Hardy, to go through each matter, starting with A, and just highlight any response that you have. There may be one or two which you accept, the comments that are made, but give you the opportunity to respond, and we can discuss each point as we go through. This may be easier than going through section 5, which it was more a general discussion. So, Mr. Wainwright, over to you, and any comments on item A.
Thank you, Mr. Bray. Before I provide a direct response to that, I think it would be worthwhile me just setting the scene for some of the responses that I'll be providing to some of these matters. And that's just to highlight that SEPA LUPS 31 provides a consistent approach that is aimed at identifying the likely risks to groundwater, not demonstrating a complete absence, as the council appears to be seeking. The guidance applies across the whole of Scotland, and its adoption for assessing risks to private water supply was found acceptable to the reporter on the Aracluic extension PLI, as was the use of the source pathway receptor approach. Both approaches are integrated within this private water supply risk assessment and the environmental impact assessment. So
just check that we've got that decision. Sorry, I don't have that.
Oh, sorry, I was just about to provide you with the reference
fine,
there, Mr. Bray. Sorry, should have done that first. So it's core document 8.001, and it's paragraphs 4.149 to 4.152, and also paragraph 4.143. So thank you. And so I'll just go on to talk about the mitigation now. So the first point relates to the investigation that was proposed by way of mitigation. So I do not agree with South Ayrshire Council that intrusive site investigation would pose a risk to the Dovington private water supply. And my reasons are set out in paragraph 5.2.8 and 5.2.9 of my hearing statement. The intrusive investigation would be at turbines 2 and 3 and would target the region where hazards would be introduced, i.e. the planned foundation-based levels. The SI is to confirm the pathway, not to confirm the source of water in its entirety. It's associated with protection of the supply from the development, not in terms of its full and entire characterization. The EIA and private water supply risk assessment identified that risks to the Dovington private water supply could exist locally via minor unmapped bedrock structural features. In order to accommodate for any uncertainty, the private water supply risk assessment assumed a likely source pathway receptor linkage via these structures, and that mitigation to limit impacts should be provided, and these include fuel handling and storage, as well as careful drainage design and dewatering plans. The final design and scope of the site investigation would be approved by South Ayrshire Council. Conditions on this mitigation have been imposed, and there is no suggestion that SI identifying no pathway would remove the need for any of these mitigations. As such, validation through site investigation would provide reassurance to stakeholders that the risks have been considered conservatively and robustly. Therefore, the purpose of the site investigation is to enhance residual risk minimisation and validate the findings of the existing assessment. SEPA also advocate the use of intrusive investigation under section 3.18 of their LUPS 31 guidance when considering groundwater abstractions and risks. The site investigation would be subject to environmental management and mitigation measures secured by condition. South Ayrshire Council would be consulted on the design of these, as would other interested parties, and the other interested parties is stated explicitly under paragraph 3.30 of core document 1.004, which is chapter 3 and is the EIAR project description.
Just coming back on that, Mr. Wainwright, in terms of the SEPA guidance, the LUPS guidance 31,
yep.
Does that refer to site investigations as a planning condition, or is that more general reference to site investigation to assist assessments?
It refers to intrusive investigation that can be used to design a conceptual site model, but crucially, it only recommends that intrusive investigation happens where an abstraction and development infrastructure buffers are intersected, which is obviously not the case here. The abstraction is 660 metres from the nearest excavation greater than 1 metre deep.
Guidance doesn't explicitly advise that be used as a condition, or it's. I suppose the simple question, excuse me if it's too simplistic, but was this information that you could have got beforehand and informed your assessment? Reassurance isn't normally necessarily something that is called mitigation. So maybe that's too simplistic a question.
No, I accept that, and yes, the primary reason was validation. So the assessment has been determined sufficient without the site investigation, and that's confirmed in the SEPA response to the Section 36 application and additional information.
So is it needed?
We recommend it to manage the residual risk minimisation and provide comfort to the stakeholders. Is it needed in order for us to determine the risk to this supply? No, it's not. We've conducted a comprehensive risk assessment as it is based on site-specific information.
Does the council wish to say anything? Item A, in terms of the response you've heard, Mr. Wainwright.
If I could just start off by one point before handing over to Dr. Dewhurst. Mr. Wainwright mentioned document CD 801, the Erliach, I hope I'm pronouncing that right, wind farm report, and in particular paragraph 4.152. That has obviously got to be seen in the context of the detailed considerations in relation to that application, and also the last sentence of paragraph 4.152, and thereafter then the detailed analysis that the reporters carried out in relation to the evidence on the private water supplies. So it's got to be seen in that context, and the conclusions. With that introduction, I can hand over to Dewhurst.
I was just going to comment that intrusive site investigation would be carried out anyway wouldn't it, Mr. Wainwright? Because you need that to determine your foundation design. So perhaps you could expand further on what you're proposing to do in terms of managing risk to the PWS from your site investigation, do you think? So it's not clear in your document.
So I've not stated that it will manage risk. I've said that it will improve the confidence and manage residual risk minimization, which I appreciate is perhaps non-premature. Maybe that's the phrase with regards to that. So yes, there will be geotechnical site investigation to inform things like foundation design. And the point that I'm making here is that I think that there is clear benefit in including the assessment of the groundwater within that site investigation campaign in terms of understanding and validating the findings of the private water supply risk assessment, which have assumed a pathway.
Does the council regard what's been proposed as mitigation?
I wouldn't regard it as mitigation. I would regard it as investigation. It's not a mitigation. An investigation, site investigation, is not a mitigation against risk. It's a way of collecting data.
Okay. Mr. Traynor, any comments on that?
Excuse me. I think doing any exploratory site investigation, which involves drilling down into the area above our catchment, has the potential to destroy, damage, whatever you want to say, our supply, because nobody knows where it's coming from. So if it's coming through, for instance, a fracture or a fissure, and somebody drills down and hits that particular fracture or fissure when they don't know where it is, then it'll have an impact on our supply. So I would say it's a concern. I was unaware until the last couple of days that there was actually a proposal to drill for the geological foundations for turbines. I thought the proposal was only for exploratory boreholes with regard to clarifying the pathways for our private water supply. And the danger to me is that the supply could actually be disrupted or destroyed by any exploratory drilling on this side of the ridgeline, above the abstraction and within the catchment and within the recharge zone.
Owen, you've had your hand up.
Yes, thank you. With regard to the exploratory drilling, that would take place should the turbines be placed in turbine 2 and turbine 3 areas and possibly turbine 1. My argument from South Ayrshire Council is that turbine 2 and turbine 3 should be removed because any intrusion, any change in land use in that area has the potential because it's such an unknown. And that's what I based my argument upon, and it's further backed by Dr. Dewhurst's report. With regard to the uncertainty in the components, the uncertainty is too great, in my view, as a person who works with people with private water supplies day in, day out, especially now in the changes to the weather conditions that we're having, the drought that's being experienced, the distance from the mains, and the other factors that may come along in the future for ground use change potential. The impacts impacts, the cumulative impacts here, again, I honestly feel they are too great to take any risk whatsoever of a private water supply. That the key factor in any private water supply, as I was previously on private water supplies most of my life, and the key factor of a private water supply is you leave them alone, you don't touch them.
Thanks, Mr. Lord. Mr. Wainwright, you've hand up to respond.
I just wanted to respond to Ms. Trainer there, and more to try and reassure her, and I apologise that I can't completely reassure you, but we have done an exhaustive investigation. What we're saying is that there could be a very minor risk associated with structural features, but the majority of the water sources serving the supply won't be impacted. So the site investigation that would occur, it is unlikely to result in an impact on the supply, and we've demonstrated that in the assessment. That's highlighted that there. We're suggesting that the foundations and the turbines would not have an impact, and so I don't accept that site investigation would either.
I should have perhaps said at the start is that we should probably consider the mitigation in the context if ministers were to consent, because you don't necessarily need to run over some of the arguments that have been run over this morning. It's really to discuss the mitigation if that was required. Before we go on to B, item B, Mr. Trainer.
Sorry, just briefly. Sam has just said there it's unlikely to have an impact. He didn't say it will not have an impact. He said it is unlikely to. That's not good enough in my view.
Item B then, and that's the micrositing. Acceptability in general terms, I think, from the council. Was there anything, Mr. Wainwright, there in the council statement that you wanted to come back on?
Thank you, sir. Yeah, related predominantly to the reference to the buffer zones there. So we've obviously considered the fact and highlighted the fact that the development is significantly outside the SEPA Land Use Planning 31 buffers, which is the statutory guidance for protecting groundwater abstractions. Notwithstanding this, additional safeguards have been put in place to enhance and further minimize the risk. So that's the main points that I wanted to bring up about item B.
Would that allow no micrositing in the direction of the private water supply abstraction site? Would that still allow for turbine 2 to be microsited into your indicative surface water catchment area? Although you might not be closer to the abstraction, but you could be into your light blue zone from the other diagram.
I think is
that possible?
It will not be towards the abstraction. So
But would it be possible with that mitigation in place for micrositing to take place into the your indicative surface water catchment area?
Micrositing proposals would be reviewed as part of the role of the clerk of works. So they would consider things like what are the potential impacts on receptors. What we've said is micrositing should not happen in the direction of the supply, but in terms of into the indicative catchment, I think that that's something that the ECAL would consider as part of their consideration of the risk.
So what you're saying in answer to this is yes, it would allow for that to happen, subject to what you've said, obviously, but in terms of that specific mitigation, it wouldn't prohibit that. So
yes, it wouldn't prohibit it, but it my opinion is that the ECAL it's unlikely to be allowed to be microsited in that direction.
Does the council wish to respond, and perhaps in relation to the comment I made also?
Yeah, I believe that currently that the micrositing would impact the catchments that have been defined by myself and by Mr. Wainwright. And that is true of all of the mitigations that are discussed in paragraph 6.1.2, because they all relate to the construction compounds and the microsite areas, which we've shown that overlap those catchments. So I would also query why that would be up to the ECAL on the site during construction.
So I don't know if you want to come back, or whether or not it has been considered in your consideration of mitigation, whether or not it would have been appropriate to not just exclude going any nearer to the extraction, but exclude going into at least the surface water catchment that you established yourself.
So the indicative surface water catchment is based on a digital terrain model. When we were on site on Monday, I pointed out that the topography of the ground in the vicinity of that area has been modified. That's something that Dr. Dewhurst mentioned there as well. The surface water catchment is unlikely to extend as far as the indicative catchment. So even if it were moved into the indicative surface water catchment, it would not change the risk. The risk has already considered the fact that the indicative catchment is not reflective of the actual catchment, which is smaller.
Mr. Trainer, you have a number 1 beside your hand, so I'm coming to you now. I think you're on mute.
I think that was an accidental number 1.
That's an accidental number 1.
Sorry. Need to have it on.
Dr. Dewhurst.
I'm sorry, but Mr. Wainwright the applicant has presented a surface water indicative catchment, which he's based his risk assessment on, and he's now telling us that that's not real, or no, that's not his assessment of the indicative surface water catchment. So why has he presented it as such? And I mean, I haven't questioned it. I've just used it as a surface water catchment, as it looked reasonable to me when I looked at the similar LiDAR data. And then he hasn't incorporated any of the groundwater catchment that could potentially be feeding water to the abstraction point. So it does seem a bit strange that he's suggesting that the mitigations could still occur within the catchment that he'd already defined.
Sorry, just to respond to that, if I may, Mr. Bray. So, Dr. Dewhurst, in my hearing statement, paragraph 4.2.13, that explicitly outlined the results of those surveys. The private water supply risk assessment also highlighted the fact that the indicative surface water catchment is not reflective of the actual surface water catchment. That's something that I've been very explicit about throughout. I don't think it's appropriate to suggest that this is new evidence, because it isn't.
I'm not suggesting that it is. I'm not suggesting it is. I'm just suggesting that you should have altered your diagrams before you published them, maybe.
Have you included a diagram which shows anything than your indicative diagram, Mr. Wainwright?
So the indicative diagram, the indicative catchment is presented in many of the figures. In the private water supply risk assessment, under the risk assessment section 6.2, there is an annotated figure which I will draw your attention to, and that makes commentary that was based on site-specific observations about the catchment. So I would refer to that in the first instance.
Thank you for that. That's really useful. Okay, I think I've had the answers to my queries on item B. We have discussed item C. Anything additional, Mr. Wainwright? I think you've summarised previously with regard to these matters. Anything additional you want to say in response to what the council said?
Nothing in particular. I think that my points today, the points of my hearing statement and the environmental impacts, water supply risks, cover off the reasons why they cover off a response to those. Be satisfied with that.
Council, anything in particular there before we move on to D?
I have no further points other than the one I just made about the catchment areas.
Thank you. And in terms of D, welcomed, but there are some comments. Mr. Wainwright. Oh, you might be on mute, Mr. Wainwright. You might be on mute, Mr. Wainwright.
Bound to happen to me at some point, wasn't it? Bear with me one moment. I'm just finding my notes. Yeah, so in response to this, we've identified the catchments, the buffers have been identified, and additional mitigation has been proposed. The reasons for removing the opportunity for placing fuels and oils and things like that within the broad vicinity of T2 and T3 as part of the residual risk minimisation. It removes the hazard as far as possible. And that's the purpose of that, to prevent the opportunity for pollution.
Does the council want to respond over and above what you've said at item D? Dr. George, no. If you do have anything as we're going along, Ms. Trainer, just use that hand, remember. So on to E, on to forestry. So comments there with regard to that item of mitigation. Mr. Wainwright?
Yeah, so I'm a little unclear about where this came from. This isn't stated in the mitigation sections. We've considered risks to forestry. That's been outlined. Changes to surface water quality and quantity that could arise from pollution, siltation, changes in land use, that kind of thing, that they've been considered in the assessment. Forestry is part of the development. Forestry safeguards will be included within the SEMP. There's obviously existing forestry operations, chemical spraying, that kind of thing that's occurring at the site. Anything that would be undertaken as part of the development related to forestry would be controlled through the environmental management plans, which South Ayrshire Council and SEPA would be approving.
You've indicated there that it's not one of, for want of a better phrase, your listed mitigations. Dr. Dewars or Ms. Loban, would you like to respond to that in terms of where that came from?
It's part of the overall cumulative risk factor that we look at for the private water supply in general, regardless of what the application is for land use change. Mr. Wainwright's correct in that there are forestry operations going on Craiginmoddie Hill, on the hillside behind the Domiston Forest area. which is left in situ at the moment. My worries about the construction phase would be the proposal to go in and do keyhole felling, then take out the forestry in small keyholes, and then go back in, put the turbines in, and then at a later date, not too far in the future after that, the rest of the wood would have to be felled because it's at maturity for felling anyway. That's why felling operations are ongoing. We at South Ayrshire Council Environmental Health do look at every application for forestry with regard to private water supply, and I'm finding increasingly problems occurring with understanding of the nature of private water supplies from the catchment down. Usually, if I mention private water supplies to forestry contractors, they are aware of properties, but not the catchments. It's the compounding effect of everything. Forestry has to come down first, and then the roads have to go in, then the turbines have to go up, and the construction has to happen, and then the foresters come back in and reforest and re-landscape. Basically, it's a land management plan. It's not just forestry.
This is a wider concern that doesn't form part of the applicant's mitigation that you're pointing out there. I suppose my question back to you, Mr. Littlewood, is that if there wasn't a proposal for a wind farm, at some point the forest would be managed involving felling. Would you, as the council, have a problem with felling within that area? Would you attempt to prohibit that? Would you have any control over that?
What we would do is what I've done already and discussed with the forestry operators, where they're felling, when they're felling, and how it's being managed, and no distance, etc. And what the time limits are. It usually comes in through planning on plans, and I ask for a risk assessment that is site specific to the private water supply, or supplies plural, depending on how many there are, and property specific to the properties on those supplies. In this case, Dogginson's one property on one supply. So we would look at that, and I would be expecting a map back, no greater than 1 to 5,000 approximately, because detail can't be gleaned from anything that's of different size. As we have discovered in the past, myself and the colleague from SEPA, we both look at the same maps, we both look at the risk assessments, and we look at the information, and then we carry out a site visit. We wouldn't necessarily stop the felling. However, if the felling was deemed to be of grave danger, considered to be a grave danger, and we couldn't agree that it wasn't going to be a danger, then it has been requested that the felling is done by hand and taken out very carefully, or left in situ. So there are mitigations for forestry, but with the fact that the wind farm construction is coming behind, might mean that the mitigation, that the gentle approach, might not be able to be taken in this case. But yes, we do look at forestry. We look at every application on their own.
Mr. Wainwright, I think you lined up to respond.
Yes, thank you, sir. And it was just to highlight that the majority of the information, if not all the information that Ms. Lobens said that she would require, she's been provided as part of this application, and there will remain an ongoing opportunity to discuss environmental management that's associated with the forestry. That's going to be secured by way of condition. And just to highlight, forestry is included as part of the project description, so it will be part of the good practice mitigation that South Ayrshire Council will have the opportunity to be consulted on and approve.
Just a moment, a brief point perhaps, is it?
Yeah, it's very brief. It's just to point out also that in the process of forestry, they don't go as deep as the foundations of turbines, and they don't go as deep as the depth required for roads, and it certainly don't create as much disturbance to the ground unless it's a real serious problem, in which case that would be looked at in its own right. But in general, forestry is shallow. As you can see, as you saw yourself, Mr. Bray and the other reporters would see with fallen trees.
Well, you make those points. In terms of monitoring now, item F. Monitoring. We've obviously considered, the council's considered monitoring acceptable with regard to other private water supplies that we've discussed today, Glenalla and Doughty Cottage. Intent in general terms with monitoring, but in this instance, I think you're concerned. Mr. Wainwright, do you want to start us off in terms of responding to what the council has said with regard to item F, the monitoring plan?
Certainly. So the private water supply quality and quantity monitoring would be outlined in the private water supply monitoring and method statement and would be prepared prior to construction in consultation with South Ayrshire Council and SEPA. And this is outlined in section 7 of my hearing statement. The practical and logistical arrangements of this monitoring would be discussed with stakeholders as part of the preparation of the document and would require with dialogue with the private water supply user where monitoring is required. No development could take place until the monitoring arrangements have been finalised and the statement is approved. Once approved, the condition requires to be implemented in full, which the applicant would commit to.
Absolutely. I'll come back to the council, and perhaps if you could explain in terms of the difference with regard to accepting monitoring at Doughty Cottage, is it with regard to the risk that's involved, and why you would be concerned that monitoring wouldn't be an acceptable form of mitigation here?
Sorry, I don't quite understand the question, sir.
Oh, sorry, that was to the council.
Oh, sorry.
It was just to really explain why monitoring is acceptable at Doughty Cottage, where there is, an element of risk, but the monitoring is acceptable. But mitigation in the form of monitoring here is not considered acceptable.
Mr. Bray, sorry.
Well, it's not acceptable, but you've got concerns about it.
Are you meaning as in Craiginmoddie and Dobbinston, in reference to Doughty Cottage?
Yes.
Right. Doughty Cottage is a different situation. Yeah. Completely different area, completely different land and different connection. Much lesser risk, as stipulated in the risk assessments by both Mr. Wainwright and Dr. Dewhurst. I don't think the monitoring situation would be suitable in Dobbinston because the risk is too great, in my view. Because the risk is too great, we need to mitigate that risk out completely, remove it completely. It's possibly a difference in opinion of risk from the companies, from environmental health to Mr. Wainwright's company. But environmental health, if the risk is too great, you take it out, you remove the risk. If the risk is to human health, human well-being, if the person could die or become seriously ill or hospitalised because of that risk, and that's the potential here. I'm not saying it is what's going to happen. I'm saying that is the potential here. That risk has to be removed. It wouldn't be acceptable to go into a cafe or a shop and say there's some risk, but we don't know what the risk is. We don't know where the risk is, but it's okay to eat. Then you eat and you're ill. that would be, you'd have to take that risk out. So it's the same with private water supply, because you're consuming it at the end of the day. It's water that's going into the human body, and it's not just two people's bodies it's going into. It's visitors and friends and family, etc. It's too great a risk, and that's why I would say monitoring's not acceptable, because I don't feel the risk of having the wind turbines placed where they are and the road where it is acceptable.
Thanks for that, Ms. Murray.
Is that what you were looking for?
Yes, that's clarified that it's in relation to your assessment of risk. That's absolutely clear. Thanks for that. Mr. Wainwright.
Thank you. Yeah, it was just to highlight that I disagree with the statement that Ms. Lobens made there in terms of risk, and that's for the reasons that I've previously outlined today, related to the risk assessment and the assessment that we've provided.
Could I just come back in, Mr. Bray? I've just missed out one point that I had written down at the monitoring plan, because of the time elapsed between the monitoring and the analysis of the water as well, because there is quite a time span in that. It may miss the critical fracture zone supplying the private water supply point, the contamination. It's time and contamination. By the time the contamination gets into the human body, gets into the tank, gets into the system, because it won't just get into the system, it will be contained in the system. Pollution, as we've seen before, can be contained. I've had an horrendous one we've been dealing with just recently, trying to get the pollution out of the whole system, the tank, the houses, etc. So it's a critical factor in that the time lapse as well. The monitoring doesn't always pick that up until after the event. We need to stop the event happening. Sorry.
I think you're quite clear that your point is on other supplies with lower risk, you accept monitoring in relation to the risk that you've assessed, but you have a different view with the Dobbington supply, and that's why you're making the points on monitoring. So I'm quite clear on that. I think.
Yes, thank you.
Trainer, you have your hand up.
Yes, I do. A monitoring plan. I'm not quite clear how that works. Sam, you're saying it would be discussed with stakeholders. I'm presumably a stakeholder. If I'm a stakeholder, what happens if I say, no, I don't like that bit of your monitoring plan? I'm not having that. And I'll give you the reason. This has already been mentioned earlier by, I believe it was Dr. Dewhurst. I currently don't allow anyone to touch our water supply. And the reason for that is because of the forestry development at the back of us. They were doing various surveys, assessments, whatever, up on the hill. And during that period, when they were all going up onto the hill, I don't know, the sheep must suddenly have got very strong, and they broke the top of the casing for our abstraction point. The same sheep that must have been really clever managed to climb the fence into the holding tank, remove covers on the holding tank, and not replace them. So, you know, I have a concern, and that's why I don't allow anybody to touch our supply. Now, I was never like that before, because of the damage that has been done previously. Now, if you come up with a monitoring plan, and I'm not exactly clear what that is, if there is a monitoring plan, you presumably will come to me and say, here's what we're proposing to do, and you will ask my opinion. Is that correct?
Plan will be discussed with stakeholders, including yourself and South Ayrshire Council. It will be an ongoing dialogue. The reason that the details of the monitoring provisions haven't been provided is because those conversations haven't taken place yet. My experience is that these conversations will take place as part of the preparation of the document, and the discussion with the stakeholders, such as yourself, would happen prior to construction.
Okay, so you still haven't answered my question. what would happen if I said I did not approve of one particular aspect of the monitoring plan, or I did not agree to that? What then happens?
It would be a dialogue to try and find a common ground or find something that was appropriate. The mitigation and monitoring here is to monitor to provide ongoing monitoring of the water quality and quantity. I have already outlined the reasons why I do not believe there will be a change to those, and that has been outlined in the risk assessment that was provided with the EIA and additional information.
You're still not answering my question. What happens if I say no to a particular aspect?
So I wonder if I can just jump in there. I don't know whether that's terribly helpful, because it's a conditions matter, really. Of course, you can't force anybody to do anything. Ultimately, discharging conditions is a matter for the council. And if a member of the public, not just in relation to water, but noise monitoring or whatever else, doesn't want that to take place, that's a matter for them. That wouldn't stop discharge of condition regardless of that position, because the applicant has done all that they can. So there's obviously a right for somebody to be intransigent. I have to say I don't think that's very constructive or helpful, but it wouldn't necessarily stop the discharge of a condition.
What I was going to say was that related to conditions, because this monitoring and the mitigation could be captured by conditions, and those conditions are, if you like, discharged by the local authority in section 36 consents. So it comes along with a deemed consent, and it would be a matter for the local authority to discharge. If there was any impasse there, then it would be a matter for the local authority and the applicant to resolve that primarily. So that's just a little bit of background, if you like. Ms. Lohman, any quick points before we go on to item G in terms of emergency responses?
Yes, thank you. And it was just to Mr. Hardy regarding discharge of conditions. If they weren't able to discharge conditions satisfactorily, they weren't able to prove that they could discharge the conditions, what would happen then? I think that's maybe what Ms. Trainor's trying to get to. Correct me if I'm wrong.
Well, I think you'll probably be able to get that sort of a discussion in terms of the conditions hearing, where you have the planning experts sitting around the table. But I don't know if Mr. Armstrong has got any thoughts on that further for Mr. Trainor. But that's my understanding, is that it is a matter for the planning authority, which would be South Ayrshire Council, to resolve that, to discharge that condition, to achieve a satisfactory scheme or monitoring plan for it to be approved. But that's theoretical, looking into the future. I probably want to get us back on to just talking through the mitigation rather than the machinations within the planning department of South Ayrshire Council. But Mr. Armstrong, did you have anything just to add before we moved on?
I've got nothing further on that point at this stage, and that's a matter we can deal with in the conditions session.
In terms of emergency response, we're talking about alternative supplies here. Mr. Wainwright, do you want to kind of respond to Council's concerns? That's item G.
Yes, sir. Thank you. So alternative water supply arrangements, including those for a short-term period or longer term, would be agreed with South Ayrshire Council as part of the private water supply monitoring and method statement and emergency action plan, which is draft condition 36. No development could take place until the statement is approved. Once approved, the condition will be implemented will be in full. It is anticipated that further discussions on many of the practical and logistical components of this plan will be discussed between the applicant, South Ayrshire Council, and the SEPA. In order to establish the contingency plan, discussion will be needed with Ms. Trainor to understand and accommodate her water supply requirements. This would happen post-consent but prior to construction, in accordance with the wording of the proposed condition. With regards to the feasibility of a permanent new supply at Dobingston Farm, which is referenced under paragraph 6.1.1, item G, which we're discussing, that a replacement supply is unlikely to be successful unless placed in a similar location to the abstraction. I disagree with this conclusion. My understanding of the hydrogeological setting of the farm is that it is also within the same Swanshaw sandstone bedrock as the development, and bedrock groundwater flow is again predominantly in structures such as fractures. A borehole could be used to target subterranean fracture systems, as is my experience in conducting water feasibility assessments for new boreholes, focusing on providing alternative water supplies in this same bedrock elsewhere in South Ayrshire. As previously stated, in order to establish the contingency planning or contingency to supply, discussion will be needed with Ms. Traynor to understand and accommodate her supply requirements. The applicant would be willing to discuss a permanent alternative supply arrangement with Ms. Traynor and South Ayrshire Council as part of the private water supply method statement, and that would be in operation prior to construction, and again secured by way of condition.
Let's clarify that last point. Could you repeat that?
Yeah, so just really clarifying in terms of permanent alternative arrangements. So the applicant would be willing to discuss permanent alternative supply arrangements with Ms. Traynor and South Ayrshire Council as part of the method statement to provide a permanent alternative prior to construction as part of contingency arrangements.
I'm probably going to come to Dewhurst now, I think, with regard to the concerns that have been highlighted. Would you like to add or respond to what Mr. Wainwright has just said?
I would just like to bring to Mr. Wainwright's attention, he may not be aware that the neighbouring farm at White Hill has a borehole that is not very it's not very consistent in its yield, and that is one of the reasons why I put that comment in the report. It's not to say that other parts of the Swanshaw sandstone aren't viable aquifers. It's just that the evidence in the local area suggests that this area would be particularly difficult.
And it's for that reason that suggested that a dedicated feasibility study could be provided with the private water supply monitoring and method statement and an emergency action plan. And that's obviously at the discretion of the council to request that or approve that. But we're suggesting that that's something that could be explored, and that would provide the detailed assessment that would look at a specific supply at the farm.
Mr. Loban, perhaps I could ask you, is this approach that has been taken by the applicant a commonplace in terms of you're working with other types of development? Is that a standard approach?
Mr. Bray, a standard approach, how do you mean offer of alternative supplies?
Well, in terms of putting in place emergency contingency planning and offer of alternative supplies.
Emergency contingency planning, we request an emergency action plan so that we have a named person 24 hours, 7 days a week that can be contacted and can contact it. It works both ways. It's a two-way communication. It's not a one-way communication. So the EIA is in place to secure safety both ways. If an accident happens, we can notify the owners, and vice versa. If something happens, they can notify us a problem. Contingency plans, we in environmental health would not consider a Bowser to be a suitable alternative for longer than roughly 2 weeks. Alternative supply in the area, as I mentioned previously, is a great distance from the mains connections, the possible mains connections, and the most suitable mains connection. I've already looked in that area for a different estate supply. It's miles from there. With regard to a bore well, bore wells in themselves bring a lot of financial burden if it's not already in place for the owners of properties. There's regular maintenance has to take place. If it were to dry out or pull up grit or dirt, you could be looking in the region of hundreds of thousands to correct a problem should it occur. I have seen that in the past few years with at least 3 different bores. And last year was the most recent one when the owner didn't realise there was a drought on and drew some gritty water up through, and it's cost them quite a number of thousands of pounds to get the lining sorted. So they don't come as an easy fix. Maintenance is costly. You need pumps to run them. You need electricity at the site to run the pump for obvious reasons. You need protection during frost. You need protection during the hot weather because fires can start if they overheat. And then the water's got to get down to the property. Would it be a suitable alternative supply? I can't answer that. I don't think it would be in the area, but I'm not the expert hydrogeologist, hydrogeologist. It has been offered in the past. It has been successfully negotiated on a couple of occasions. It has been refused, and turbines have been refused because of objections to it in previous applications as well. It has been offered in another area of South Ayrshire Council where they wanted to sink 2 bore wells in replacement of the extremely good water supply, very similar to Dobingston, I might add, with good quantity and good quality water. And should they have gone ahead with the bore well, they'd be in the same situation as the wind farm is now with no water, because the wind farm put their own bore in and it failed after just about 2 to 3 years, not even that. So it depends on where you're taking the water from. There are bore wells, maybe not quite in that vicinity, and that are shallow, maybe a bit further away, and they're quite shallow, and you've got the possibility of drawing up unwanted content like arsenic, for example, or aluminium, depends on where the water's coming from. It's an unknown quantity. You don't know where the water's coming from. Very expensive piece of equipment to put in, and then if the water just suddenly stops because it's not got a recharge zone, because you don't know where the water's coming from, that's you left without any water at all. So there's a lot around an alternative, suitable, potable water supply. It's not simply a matter of let's sink a bore well, or as some have suggested in the past, let's put you onto a neighbouring supply. That would be even worse because it's privately owned, it's on private land, and it would impact other people and other users and impact an already drying climate.
Okay, thank you for that, Mr. Wainwright.
Okay. Thank you, I just wanted to highlight that the boreholes are commonly used in rural water supplies, as Ms. Logan's well aware, and they can be resilient, far more resilient than, say, surface or spring supplies on account of where the water is being drawn from. And I appreciate that there was a lot of site-specific detail that Ms. Logan's gone through there. That can result in that changing, so that the point that I want to bring up and draw your attention to is that the minute we're not discussing the practicalities, what we're trying to discuss are the principles and the use of contingency plans, which is what we've suggested here, that are comprehensive and will be approved by South Ayrshire Council. It is the principle of those that we are discussing, and that is the mitigation that we are putting forward.
Okay, thank you, Mr. Wainwright. Dr. George.
Wainwright's quite right. Boreholes are quite commonly used for rural supply and public supply. However, the current private water abstraction has been shown to be running throughout the year and to be a good supply. You cannot guarantee that in a new borehole that you would get that. And And that's all I was going to say. Yeah, and the longevity of it as well.
So when I'll offer you the opportunity to come in. I think you might be muted again.
Oh no, I was about to make a point, but I think it's just reiterating things I've already said. So thank you, sir.
And Ms. Globin, have you got any additional points? No need to reiterate anything that you've highlighted before.
Sorry if I was. No, I've had quite an experience of bore wells over the past 2 to 3 years with problems, showing problems. That's just the bore wells. And a large number did run dry in 2021. They were stopped from taking any more water out just before they pulled up the silt. So manufacturers were sitting without copious amounts of water and had to then that's one point. The other point is I think Mr. Win. Oh, sorry. Can you hear me now?
Yeah, if you could just repeat the last couple of comments that you made.
Can you hear me now? Yeah.
Yep.
The bore wells, in my experience in the last 2 to 3 years, have been failing in this area, and I agree with Mr. Wainwright. Across the country, they are commonly used, to take up private water supply for various reasons. But in this particular area, in the south of the South Ayrshire Council area, the Carrick areas, they have been failing in certain times of year. And in 2021, manufacturers stopped using them because the water level had gone so low. The indicators showed that if they carried on, they would pull through silt. So to stop damage to the wells, they stopped using them and applied for abstraction licenses from Penmaple Reservoir. That's to keep the manufacturer going, and that was for a number of months. That went on for quite a number of months. The mitigation, I think Mr. Wainwright is talking about, is emergency supply as well. Bowsered water doesn't solve problems. It gets water to a property. How would the water be brought up to Dobbingstone? Because the property is quite a distance from the main road. It may well be brought up in the back of a lorry or a bowser. If it's Scottish water, the bowsers fill from the bottom, so it's not an easy thing to use. That's why we don't use them supplying emergency water. When we give out emergency water, we give out bottled water because we've no way of filling them. Nobody, unless you've got some mechanical means of filling it from a hydrant from Scottish water. So it would need to be a certain type of bowser to enable the residents to use it. Once it's up at the farm, where would it go? Would it be placed inside? Would it be placed in the sunlight? Are we going to be looking at further contamination of other things like the plastics, etc., growth of mold, etc., in the water? How long is it going to be there for? How do they get it into the property? Remember that the whole concept of a suitable potable water supply within a property is within the property. It's not a bowser outside in the yard, not bottles in a barn. That's an emergency supply. So we're looking at a 2-week window, roughly. We would agree a couple of weeks to get something sorted out, but that's only if there's an emergency. And an emergency shouldn't happen unless it's unforeseen. And we are looking at this application as a whole here. The other supplies I don't have problems with, but this particular supply, I don't think the problems we're looking at are unforeseen should they happen. There's too much uncertainty to say we don't have unforeseen problems here.
Mr. Wainwright, wish to reply.
Thank you. With the greatest of respect to Ms. Loban, she is labouring the practicalities there, and what we're here today to discuss is the principles. We are here to discuss the principles and acceptability of a contingency plan, which what Ms. Loban's outlining are things that must be considered and would be considered as part of the condition discharge process. It will be the responsibility of the applicant to provide a supply, and that will be secured as part of the contingency planning. Really, the principle is what we're talking about, not the practicalities. And I do appreciate that there is a lot of detail that will need to be talked about, but this really is the vector to have that discussion and find those acceptable those acceptable elements that Ms. Loban's referring to.
Okay, thank you for that. But still interesting to hear, nonetheless. Can we move on to the item H? I think the council there are saying that, or the hearing statement is saying it's not really site-specific mitigation, but I don't know if you've got anything to respond to, Mr. Wainwright.
Yeah, that's taken from that spill response training is taken from the good practice mitigation section of the private water supply risk assessment. It's not an additional information requirement, an additional mitigation requirement. Sorry. So that's perhaps a point of clarification. Spill response training is an integral element of general training that would be delivered through the SEMP. So details on that would be provided as part of the construction environmental management plan, and the entire site would be subject to spill response procedures, including spill response training for on-site operatives.
It's not additional specific to issues that we're discussing today. There's additional mitigation. Ms. Traynor, I think you wanted to come in.
Yes, I did. Sorry, I didn't press my button quickly enough. I wanted to get in on the last point, which was the emergency. Sam's talking about, putting emergency supplies in place if required. I do not want to end up in a position where we have bowsers in the yard and I have to go and lift the water with a bucket from the bowser to fill my toilet cistern. And I will be unable to have a shower. I will be unable to do washing, anything like that. And this has happened in other areas as far as I'm aware. I don't want to end up in that position. And I know Sam's saying that we could agree on alternative supply prior to, so these emergency situations should not arise. I'm sorry, but I think these emergency situations do arise. And I don't want to be in that position. I've seen these management plans before with our experience with the forestry. And there's a big element of trust that's required. It ended up when we were working with the forestry, the development at the back of the house, that there was no trust and that we had to employ a private consultant at our cost to advise us in how to deal with these forestry folk. It ended up that I didn't deal with them at all, that our private consultant dealt with them because it was causing us too much stress. We were being lied to, we felt as if we were being bullied, and this is all my opinion. I don't want that to arise with Energy Contour. The first conversation I had with Michael Briggs or with Energy Contour was yesterday or Monday, whatever day we were out. So I don't have a relationship with Energy Contour. I don't have any trust in Energy Contour. I don't have any confidence in what they're doing because there has been zero engagement. And if we're going to have these discussions, as Sam's suggesting, to come up with a management plan or whatever, there has to be a big element of trust, which is not there at present. And I don't know how you get around that. If Energy Contour suggests to us that we would need to, they would offer to put in a bore well, we would need a bore well or whatever it is, we don't have the technical expertise. So we're going to have to employ somebody. I've no doubt Energy Contour will say, well, you know, we've got an independent body that will do this, this and this. Sorry, that's not independent. When we were working with the forestry people, we discovered that their reports were not exactly as we would have wanted them to be. And as a result, because we employed a separate contractor, a consultant to advise us, it meant that we were confident. So if Energy Contour wants to have any of these discussions with us, then we will have to employ somebody who can advise us. I don't know what a bore well is. I don't know what it looks like. I don't know how it works. I don't know what the potential dangers are. I don't know what the maintenance costs are. I do know that the bore wells, which are used in the local farms, regularly fail. Last year, during the summer, there were pipes running from the burns to the farms in order to get water to their cattle because their bore wells were failing or had dried up completely. And Whitehill was mentioned earlier. I know that they have a lot of problems with their bore well. So we will have to employ somebody. Why should we have to lay out more money to employ somebody under those circumstances?
That, and I apologize, I should have actually come to you on that matter because of and how it affects you. So my apologies for that. Mr. Wainwright, I'll come to you now.
Thank you, Mr. Bray, and I just wanted to provide a response to Mr. Traynor there directly. So the risk assessment has indicated that overall risks are low, and that contingency is an additional safeguard. We have not suggested a new supply as a need, as direct mitigation here. What we are saying is that the applicant will, as part of the condition discharge process, discuss contingency arrangements, and an alternative supply could form part of those contingency arrangements. We do not believe, or as the risk assessment has indicated, that overall risks to the supply are low. Regardless of what arrangements are made in terms of contingency, there would be it's unlikely there would be a requirement to stop using the existing supply, so that there is obviously the opportunity to access for both if that was the route that was decided at the condition discharge stage when it comes to establishing what permanent alternative supply contingency arrangements are required. So I just wanted to clarify that for Ms. Traynor.
Do you still have your hand up, Ms. Traynor, or?
Yes, I do. There's that word unlikely again. I don't understand this. If there's any uncertainty, it shouldn't happen. It's a criminal offence. I don't get this. I'm struggling to follow it at all.
Thank you again for that. The last matter before matters that the council consider not to have been included is with regard to I think what they call the SEMP. With one comment there from the councillor. I don't know if Mr. Wainwright would like to respond aside to mine.
Yes, I think Mr. Hardy's got his hand up.
Mr. Hardy.
Yes, I just thought I'd come in before we get on to that with that last point. And there's, for obvious reasons, lots of concepts being put together, factual, policy and legal. And I think, I mean, I've listened to a number of iterations of sort of tests and what we're looking to do and the fact there can't be any risk and that sort of language. And I just wonder whether it's one of those situations where we ought to put a marker down for some legal submissions on the appropriate tests that should be applied. So I'm not suggesting we do that now, but I probably just, it's a request, I think, to try and bring some of these points together. So that's probably in closing submissions. I don't know whether or not you were going to ask for submissions in relation to this topic. But I think from what I've heard today, I would describe it as being a misunderstanding of what we're trying to do. And I think I would like to request the opportunity to put some legal submissions down in due course.
Mr. Hardy, in the likelihood, and we haven't clarified it to date, but in terms of closing submissions, generally at the end, we would be directing all the parties to what we look for, but it would be an opportunity for closing submissions on all the key issues that there's been oral sessions on.
Very good. All right.
So that would provide your channel, if you like, at the end of the process.
On this, no, that's grateful. Thank you. Thank you.
Shana, you still got your hand up. That was a mistake that time. Mr. Wainwright, were you going on to say more with regard to what the councillor said on item I?
Yeah, so thank you. Yeah, happy to provide some additional commentary on that. So site design and additional mitigation and control measures will manage risks to private water supplies in the first instance. Even in the unlikely event of a deterioration in water quality, the monitoring can be designed for rapid notification through the use of in situ monitors with telemetry. These kinds of arrangements can be discussed. These practicalities, if you like, can be discussed as part of the private water supply monitoring and method statement. It's my experience that rapid monitoring and things like that can be used and are used as part of pollution management, monitoring and pollution prevention and control on developments such as this.
Thank you. Ms. Dewhurst or Ms. Loban, do you have any additional comments over and above what you've said with regard to monitoring already?
No, I don't. Thank you.
All parties happy to move on to the issues that you've identified and not been considered with regard to mitigation. All happy to move on to that. And again, Mr. Wainwright, I'm afraid I'll come over to you and if you could go through K to M with any comments that you have with regard to these issues. We might have a discussion on each of them.
Certainly. So in terms of item K, I do not agree with this statement. Private water supply risk assessment, section 4.2 under hazards, bullet point 3, discusses the risks associated with contamination from concrete. And within that section, we've also considered the change or modification that can occur to groundwater flow pathways, both shallow and deeper pathways. And we've obviously discussed that at length today. So I won't go back over my points as there. So just to confirm that the introduction and release of concrete materials has been considered.
Thank you, Mr. Wainwright. I've got the council's view. Is there anything additional that the council would want to say, or you're quite happy with what you've said here?
I'm happy with what I've said here. Thank you. And I would expect further assessment.
So we're on to the next point.
Certainly, thank you. So again, item I, turbidity. So in terms of the private water supply risk assessment, but again, direct you to section 4.2 and the hazards, bullet point 4, the discharge of sediment from surface water networks, which will include increases in turbidity. More wider changes in groundwater quality are also considered within the assessment.
Similarly, I have nothing further to add to my statement.
And item M, in terms of the technical manual that we discussed earlier.
I think we discussed it earlier, didn't we?
Yes, I think I've outlined my position on this as has Dr. Dewhurst.
Quite clear, we don't need to have a further discussion on that. Okay, well, we've gone through the mitigation, but I think we've got some questions, at least one or two questions, but I think I'll turn to Mrs. Levin first just leave it.
Thank you. I just want to return to something that we had touched on before lunchtime. Obviously, we'll be discussing transport matters tomorrow, but if we were to assume that the applicant was using just the U25 to access the site, we just wondered whether the applicants had considered in the site design and layout the possibility of removing or not using that section of the access track between T2 and T3, and particularly from a private water supply perspective. Could the applicants respond on that first?
Mr. Winright or Mr. Hardy?
I don't know if Mr. Hardy might be able to respond to this one.
Or indeed, I'll take some instructions. And honestly, I don't know. So, and I'll come back to you on it.
Okay, perhaps, Mr. Winright, then I'll ask you, in your professional opinion, would it be a sensible mitigation? Perhaps I'll word the phrase the question that way, and that takes it away from the applicant's design. It's, in your professional opinion, having looked at the scheme, would it be a sensible mitigation given the risks to not use that existing track or not to upgrade it?
I think that I've outlined my position on this in terms of the risk, the potential source pathways and receptors. That's clear from a hearing statement. I do believe that the mitigation that we've provided is appropriate and the assessment taken is sufficient.
And did you consider the potential for that in your consideration of mitigation, and did you knock it out because you didn't think it was required, or was it not considered as part of any thought process for mitigation?
The hazards that could arise from traffic movements were considered in the assessment. So yes.
If it's helpful to the instructions I've got is that no, the track wasn't looked at separately. And the reason for that was because the council has always asked for removal of both the turbines and the track. So it's not been looked at as, it's not been singled out on its own. It was always just a package of both turbines and roadway.
Perhaps then we can ask the council that with regard to mitigation, leaving aside your concerns that have been set out, would you consider that to be a competent mitigation for a proposal of this nature?
I feel it's reasonable I feel it's reasonable to consider whether removing the road is a good idea. Yes, I think so. And I'm surprised that there hasn't been a little bit of iteration between design layout and risk assessment.
Mr. Cleven, any follow-ups?
No, I think that's helpful. Thank you.
Mr. Wainwright?
Thank you. Yeah, it was just only to add, like I've stated previously, the development infrastructure is situated outside the land use planning buffers, which is the first port of call when it comes to assessing risks to groundwater abstractions.
Yes, but we're quite clear based on your indicative a surface water catchment area that access road goes through that indicative zone.
And that's why there'll be good practice mitigation with regards to drainage and things like that will be secured in the SEMP. And then there's also the additional mitigation that we've suggested by way of further safeguard, things like fuels and oil handlings, site-specific drainage plans and dewatering plans, that kind of thing.
Okay. Well, it may be useful for the applicant either at the transportation hearing or the conditions hearing, just to be be able to maybe consider those matters further if we were to ask further questions, I think, about how practical that would be, or whether or not that would indeed be a feasible mitigation. Ms. Globan, I think you wanted to come in.
Yes, thank you, Mr. Bray. Very quickly, again, all I've heard being talked about are mitigations for water, for sumps, for drainage, etc. But we're also looking at the traffic weight and the construction weight and the amount and the continuous amount for at least a year, perhaps more, depending on the build and what problems are encountered in construction phase. And then afterwards, the maintenance regime and the traffic flow need to be considered. All of those need to be considered, along with the other points the colleagues and the different, both applicants and South Asia have mentioned.
And I know this is there's a new matter that asked a question on, but in your view, does it present an opportunity for mitigation based on what you've just said?
Yes, there's an opportunity for mitigation if it was removed completely. But to remove that completely, you'd also need to remove the turbine 2 and turbine 3, because if you remember correctly on the site visit on Monday, we stood on top of the turbine 2 centre, and that is directly in what Dr. Juhast has identified as the catchment area, or part of the catchment area. So mitigation would need to be the removal of the components as a whole, not one single, not just the access road. It would need to be as a whole.
Obviously, we're just even just introduced the concept of in a sense not using the track between 2 and 3. We didn't ask about your wider view about the wider removal of infrastructure, but it's useful to get the responses, and I think we probably will come back to that at a later discussion. Mr. Wainwright.
Thank you. Yeah, it was just to highlight in terms of what Mr. Loban had said at the start of her commentary there, that the design, that those kinds of things, loading weights, it'll all be subject to detailed design that will be provided post consent.
Mr. Breed, any further questions on mitigation, or do you have any ideas of additional mitigation, Mr. Reid?
Sorry about the delay. My mouse isn't quite working. No further questions from me, Mr. Bray.
Well, I'll maybe just ask a final question, and it relates to a previous question, is in terms of additional mitigation. We may return to it in terms of planning conditions, but would it be acceptable to the applicant that additional mitigation with regard to not micro-siting infrastructure with regard to turbine 2 within the indicative surface water area or associated roads, would that be considered something that would be acceptable for further consideration? That's just dealing with turbine 2 and associated infrastructure. Could you actually, in a sense, in short, could you actually locate it outside the indicative surface water area? Well, maybe one for Mr. Hardy first of all. Mr. Wainwright, you might not want to answer that one. It's up to you.
Certainly, mitigation is something that, in terms of the micro-siting, it can be discussed as part of the conditions. I don't think it's necessary. I understand the basis for why it might be considered.
Mr. Hardy, you'd be quite content to have a further discussion on in the planning conditions session on that matter, if we consider it appropriate.
Yes.
Okay. If there's no further queries on the mitigation proposed and our questions, or potentially ideas perhaps that we've thrown in. All happy to take a short break, and then we'll come back to talk about conditions. Just a bit of context is that given the water experts, for want of a better phrase, are here today, we're keen to discuss what we could with regard to conditions from your interests. And then there is a wider discussion on all the planning conditions with the planning witnesses and others on the 20th, I think. So it was really to discuss as far as we could with regard to your interests. But before we break, Ms. Traynor, are you happy that we can break without or was there anything else that you wanted to discuss before we break?
No, I'm fine. Thank you very much.
Oh, okay, right. So we'll come back and we'll probably have half an hour on conditions, and we're probably looking to finish around 4 o'clock by the looks of things. So we'll come back at 3:30. Thank you.
Thank you.
Thank you.
All parties seem to be ready to go. Conditions. And if we've discussed the matter before, then we might not need to discuss the detail of the conditions. But I was proposing that we use the most, well, I'm looking at the email that was sent round by the council, which extracted the relevant conditions. Are you happy that I refer to that email, because it's got that, it's got the extract. It will be the most up-to-date position. I don't know if the council wanted to just say anything more other than that was set out covering that table in the email, that you're waiting from a response from the applicants. But I don't know if the council want to add anything more, Mr. Armstrong.
It might be helpful if Mr. Lopez just sort of sets out the, where we are just now, and on that, and the structure of that email, and where there's still ongoing dispute in relation to the wording as a sort of starter.
Mr. Lopez.
Yes, thank you. So there has been, as mentioned in the email, dialogue between the applicants and the council on the draft condition document. So I think the document was lodged back in April. We provided further comment on that. I think partially or most of the conditions in early May, and then we followed up on some outstanding points early next week, and those are currently with the applicants for consideration. Understand the hope is to try and provide an updated draft conditions document at some point this week. So in terms of how I've tried to kind of structure the table fairly logically, so working your way down. So for example,
parties have a copy of the email. I'm quite happy to work for that table. Mr. Trainer, do you have a copy of that table that was emailed out?
I don't need it, I don't think.
Okay. Well, if you're struggling to follow, just let us know it, and we'll try and explain things a bit more fully. Sorry, Mr. Lopez.
Yeah, I was just trying to say that I've hopefully sort of structured that fairly logically. So there's a column for South Ayrshire comments, column for applicants' response, and then a column there for the most up-to-date condition. So hopefully that's fairly straightforward for the different parties to follow.
And as I said at the start, this is really to allow a discussion of the conditions with regard to the experts and advisors that we have here today. We will be having a detailed look at all the conditions, including these, no doubt, on the 20th. So I'll just put that rider with it. I think it might be useful if we just go through the Craiginmoddie response, and then we'll probably be able to have a discussion there. I mean, that's with regard to condition number 36. It's got a number of parts. The first matter is who's to be consulted and approved by. I mean, that's probably a matter that we'll discuss in the planning conditions hearing. But yeah. Highly unusual that you would specify specific department. But is there any particular reason that the council considers that a particular element of the council rather than the planning authority? Is there any particular reason why that unusual approach is taken?
The intention there was that there would be dialogue between the applicant and the department before there was an actual submission of the the draft for approval. And I think that was the main intention of saying that there should be reference to a consultation with the department. Let's use the term SAC there. The intention was that these matters before the document was submitted.
Mr. Hardy wants to say anything there.
General point, really, making your the point that you made. It's you don't need to specify the environmental health department. That's a matter for it to take internally. I've never seen that, and I don't think it's necessary. But nor do I think it takes anything away. Of course, they can. The council can consult with internally with who it likes.
Well, the intention was that the applicant would discuss matters with the department before they submitted the draft.
Then it can do that, but it doesn't need to be recorded on the condition.
You're making the point, Mr. Armstrong, that in some conditions the consultation requirements are set out, like with SEPA or Nature Scot or such like, that as a regulatory authority, you were wanting to point towards the environmental health service in that respect.
That's correct. So,
okay, well, we'll make of that what we will, and we might have a further conversation in a couple of weeks' time. That's in relation to guidance. In the reference to SEPA guidance there at the end before we come on to the big long list. Is there any response from the council there in terms of what the applicant has said? They've indicated it's unnecessary to refer to other legislation, but it's relevant to keep the reference to SEPA guidance to the council.
Well, the important point there is that it's making reference to just the SEPA guidance. We didn't consider that was appropriate. There's obviously guidance and advice that should be taken into account, and you either list the relevant ones or you say the appropriate guidance and advisation.
Does the applicant have any response to that? Is reference to the appropriate guidance sufficient?
Yeah, I don't think it's right to be specifying legislation. So preference would be for that for none of that to be in.
The guidance may also change from time to time, and roles may change.
Yeah.
I'm not suggesting SEPA won't be in existence at any time in the future, but it
might change its name or anything like that. So, or successor documents. So I think that's a reason just to guard against that.
Okay, there seems to be agreement there with regard to referencing the guidance. The next matter with regard to emergency plan, the applicant has given a response there under 3. Does the council have anything wishes to say today on that? Obviously, we've had a long discussion on emergency planning and contingency earlier.
Ms. Lubin will deal with that.
Okay. Yeah, I think we'd accept the emergency action plan. I'm not really sure what I'm being asked here, to be honest.
Well, the council's view on emergency plan is that Part E should be replaced with there, and then the applicant has come back with their comments indicating the only difference is that they've proposed an amendment and the applicant's content. Are you happy with that?
Well, no, we've stated it there. The update, the medical condition is not acceptable, and we maintain that the requirement for intrusive site investigation. I stand by what I've said, that I feel that the intrusive site investigation is unnecessary because the mitigation for the private water supply of Doggerson would be the removal of turbine 2 and turbine 3 and the adjoining roads. So the emergency action plan would come into play for the rest.
I think just specifically the emergency action.
Oh, right. Okay. Sorry. Right.
Them as
Well, yeah, I'm just being advised about the emergency action plan. Yes, that would be acceptable. Yeah. Sorry.
It doesn't help that the columns are quite narrow and it's hard to read across. And part 4, applicant has replied. Part 4 reflects a commitment in the EIR and its inclusion in a condition supported by SEPA. Do you have any response to that in relation to the comments that you made?
The response to SEPA is fine, but we need a response to us as the regulators for the private water supply as requested. I think I've talked that one to death, to be honest. I really don't want to have to, like you said, Mr. Bray, I don't want to have to keep going over ground, but the regulators for the private water supply legislation and the Acts of Parliament, Environmental Health, South Ayrshire Council, we require the consultation. We require the emergency action plans and the information.
Anything further?
There are actually more than one regulator in here for the private water supplies when it comes to it. The SEPA, South Ayrshire Council, and Forestry, as far as I'm concerned, that I deal with on a very, very regular basis. Probably other regulators too for other things that I'm not involved in, but for private water supplies. Yeah. So there's more than SEPA involved, is my answer.
Anything from the applicant on that particular element?
Not sure there's much to add now.
Oh. Okay. Gives us to that end of that first condition. If we're happy to sit down the document. Is there any matter on the construction environmental management plan that we've not discussed those views on already? Does the council want to say anything more on their views on the SEMP?
I don't think there's any impact.
Is there anything from the applicant on the SEMP condition? No. And the concentric planting a condition was put in. Perhaps the applicant can take us through that. And is there any concern from the council? I think the applicant's response refers to private water supply and the risk assessment. I don't know if you want to introduce that from the applicant's perspective, and any concern from the council?
I don't think there's anything I need to add. I don't know whether the council have got a response.
I think it's just as set out in the table, really. I think we just want to clarify that the replanting would be considered within the private water supply risk assessment.
Anything additional to add to that from the applicant's perspective?
No, that's fine.
And we did highlight earlier on with regard to the council's view about the removal of infrastructure, and I think I said I would have a short discussion today about that. Mr. Hardy, I think you indicated, although it's not your view, if ministers came to the view that the removal of turbines 2 and 3 and related infrastructure was a matter they would like to consider, is that something that could be discussed in the conditions session competently? Do you think that there would be environmental information within the EIAR to date that could allow a discussion of that? And can you see any practical issues or problems with that? Notwithstanding, that's not your view, but
Yeah,
it's just really to talk through the practicalities of that from an application point of view.
yeah. Well, what I can say is what's happened in the past. Clearly, it's not our view, and what we've not done is prepared graphics or material on the basis that those 3 turbines were removed, and that's for understandable reasons. We're not going to. We wouldn't have prepared that in advance. However, the view that's been taken in other cases I've dealt with where a turbine has been removed or a couple of turbines have been removed is that the view pragmatically has been taken up. There's environmental information for all of this scheme, and it is easier if you are going to delete, particularly if it's a small number of turbines, the lesser is incorporated within the greater. And certainly on things like visual impact, it's perfectly possible to look at montage and textual descriptions for you to have sufficient information to form a view. So no, nothing specifically has been done, but I think there is sufficient information if that was a view that was ultimately formed to enable the decision maker to do that. I think if you're going to start moving things, that's rather different. But if it's deletion, and particularly a deletion of a small number of turbines, then you can lawfully come to a view on, or ministers could lawfully come to a view on what you've got before you.
And Mr. Armstrong, do you have a view on that?
Well, it very much depends on what the knock-on effects are, whether it's also removing the sort of access route, the extent of what is actually being deleted. I mean, I accept Mr. Hardy's point that if it's a sort of de minimis change, then it would be far easier for the decision maker to conclude that they have enough information on the environmental effects of the change. But anything really more than the decision maker has got to satisfy themselves they have sufficient information.
Absolutely, Mr. I would concur with that. It's a question that the decision maker has to ask. So I think there's a sort of an active question. That is, have I, if we were going to consider removing these, have I got sufficient information? I think what I was saying was, in my view, the decision maker would have sufficient information. So I totally agree. It ought to be articulated that there is a question that's been asked and answered. So it's de minimis if you're not going to do anything at all, you just get on with it. But if you are going to make changes more than that, you have to actively ask the question, do I have, as the decision maker, sufficient environmental information to comply with the regulations in the Act? And my answer to that would be yes, you do.
Thank you, Mr. Hardy. And just to clarify from our earlier discussion, I think Mr. Hardy mentioned that there are turbines 1, 2 and 3, although I think there has been discussions between us today with just 2 and 3. But I think earlier on, can I just clarify, just in case there's been a change during the hearing from the council's perspective, Mr. Armstrong, in terms of your current position with regard to removal of the turbines and infrastructure is 1, 2 and 3, or was it 2 and 3?
It is as set out in the conclusions of the hearing statement at 1.1.3. That's 1, 2,
and the related infrastructure does involve infrastructure beyond laydown areas and the turbine bases. I think there is additional infrastructure in there as well. So that's what I'm going to propose is because we've had this discussion, I'm going to propose that we return to it during the planning conditions hearing to get the parties' views on that. It'll give them a little bit of time to consider. It's certainly not a proposal of any sort, but it's just so that we can have the discussion, so that ministers have all information and the advice that we can provide depending on their view on the proposal. I don't know if Mrs. Leven or Mr. Reid want to come in at that point to clarify anything on that particular matter.
I think that's, I was wondering whether it was something we would discuss at the transport hearing tomorrow, but in terms of looking at it as a whole, it might be better to leave it to the conditions hearing. So I'm happy with that if other parties are.
Yeah, I'm happy for that to be left to the conditions hearing as well.
I think the difficulty with this sort of thing is if you start drawing up plans and then it becomes like a sort of proposal, and that isn't our, you know, it's not our proposal. We don't say it's necessary. So I think the debate, which we absolutely can have, will look at what would be required, what would be removed, and whether or not that's within the ambit of information that you've that you've got at the moment. So I'm happy to put that up. We need to give it a couple of days thought, and we'll come back to that in the condition session.
That's fine. Just to kind of around that off, to give a bit of background, in reporting to ministers, we would be reporting the current view of the council, and in doing that, it would be fair for ministers to question the implications of that. So we need
absolutely.
We need to be in a position to report the implications of that. So that's why we're probing this just now.
Yeah.
It's not a particular view that we have. It's just so that we will be able to report as fully as possible to ministers. Okay. We're approaching 4 o'clock. Mr. Traynor, planning conditions are not that interesting. We probably all know that, but do you have anything to add based on what you've heard in that short discussion on planning conditions?
No, I don't. Thank you very much.
Okay. Anyone else got any comments, questions, queries before we leave today's hearing?
Thanks.
No. Well, thank you all for participating today. That's been very helpful, and I think I'm content that we've covered all the points that we intended to cover. The next oral session is a hearing tomorrow on transportation matters, and it's a virtual session as well. And Mrs. Leven, 10 o'clock.
That's great, 10 o'clock start. And perhaps just to mention that Daly Community Council, who were not originally on the participation list for tomorrow's session, have indicated that they would like to participate on the basis of their previous written submissions, but there should be an email notification of that going out if it hasn't gone already. Thank you.
Okay, right. Thank you very much, and enjoy the rest of your evening. Thank you.
Thank you.
Thank you.
Thank you.